Good morning, everybody. Happy it's no longer Monday, also known as Tuesday. It's TCF Live. My name is Dan Soul. I'll be your guide through this 3-hour journey through Courtlandia. We will get started with a kind of grumpy, weird looking, no, maybe not, Judge Middleton.
2026. And you're here for an arraignment, at least I think you are. The arraignment is the process where the judge tells you what you're charged with and asks you how you wish to plead to the charge. And then we're going to take you essentially in the order that you came in. Zachary Whaley, would you come right up to the podium and give the court officer the top copy of your advice of rights form? First.
And that's our proof of our insurance.
Yeah, we can do that. We'll enter in that illegally and then we'll show the
This is
size.
26
And he has scheduled to, we didn't know his permit
831.
expired.
This,
So that's
yeah.
after.
Perfect.
Are you Zachary Thomas Whaley?
Yes,
Mr. Whaley, you got a ticket for driving without insurance and for driving without an operator's license. We get lots and lots of these. Driving without insurance is a misdemeanor. It's punishable by up to a year in jail. Carries a fine of not less than $200, not more than $500, and it kills your insurance rates. No operator's license is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. It does carry 2 points. So let's take a look at your ticket. They can now run your license plate and they can tell whether the car is insured or not. They couldn't always do that years ago. But you got this ticket at 9 o'clock in the morning, right here in the village of Centerville. They also gave you a warning for a defective plate light. Let me ask you the same question I ask everybody else. Do you have insurance now?
yes, sir.
Do you have your license now?
I have a appointment for after this to go and get my permit. To renew my permit.
Very good. Who's your insurance carrier?
Bristol West Farmers Insurance.
You still live here in Centerville?
Yes, sir.
All right, so you have a SOS appointment today?
Yes,
240.
It may be handy just to get us a little bit of time here on it.
Yes, I think so. What we usually do with these is we adjourn a couple weeks for you to come back in and show that you have a permit again and show proof of insurance. The prosecutor could amend both of these charges to something. If you get convicted of this no insurance and you get convicted of no ops, you won't be able to get your license for about a year and you're going to have to pay a lot of money. If you now have insurance and you come in and show that you have your permit, prosecutor can amend the charges to something that won't be so expensive and so damaging. So I'm going to adjourn this a couple weeks.
okay. Thank you, sir.
And then I want you to come in with your license and insurance.
Yes, sir.
So today is somebody swiped my calendar. I blame Judge Patterson. Today's the 19th. I'm going to adjourn it about 3 weeks, which will put it not on a re-exam Tuesday, 1926 to 9. Nah, fool. June 9th.
You said June 9th?
Yeah, does that work for you? 8:30 in the morning?
Yes, sir.
A Tuesday. 8:30, right here, courtroom C with a pretrial, bring proof of insurance and permit.
Okay, sir, I will.
All right, I can't ask for more than that. You do good on your test, hold on to that insurance thing, and if you come in with both of these,
Thank you.
that'll be June 9th at 8:30.
All right, see you then.
All right, I'll be here, I hope.
Thank you, sir.
Have a nice day.
And to bring permit and insurance proof. Farmer's insurance. All right, I think he's gonna be all right. Sorry, I have one speed, it's about 6 miles an hour, but there's a lot to take care of here. Next is John Hurst. Would you come forward, please? Good morning, sir.
Morning.
You gave me 2 copies of the back page. I need one of his first copies. This is file 26-9SM. There's also an ordinance ticket for no operator's license in 268330T. These are 2 separate incidents. One is a larceny charge and the other is a traffic case. So let's take a look at these one by one. First, let's talk about the traffic case. You got a ticket in White Pigeon. On May 1st at 6:38 p.m., they allege you were driving with a suspended license. Driving suspended is probably our most common offense. It's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driver's license and requires that your license be suspended. The White Pigeon Village attorney, Mr. Seth Coaches, has taken a look at this. He sent me an email and said he would reduce this charge. He would dismiss the charge of driving suspended if you enter a plea to no valid operator's license. Shows here that your license is revoked. It would save you money and it would not require a further suspension of your license. No operator's license is a misdemeanor. It's punishable by up to 90 days in jail, fine of up to $100, and it carries 2 points. Regarding the traffic case, are you willing to plead to the lesser charge of no operator's license?
Yes.
Okay. Anybody threaten you to get you to do that?
No.
Promise you that?
No.
You understand that you're giving up your rights to have a trial in this matter by entering this plea.
Yes.
So just May 1st, wasn't very long ago. Where were you going?
I was helping a friend and we're gonna have dinner and getting vehicle parts.
Whose car were you driving?
My girlfriend's.
All right, well, she could get in trouble for letting you drive her
Sure.
car.
And since it's been, excuse me,
What?
everything's been since taken off the vehicle.
All right. Bunch of pens without ink. All right, well, that one carries $100 fine, $75 crime victims' rights fee, and a $50 state minimum fee. That's $225. Can you pay that today, or do you need time to pay it?
No, I can take care of it all today.
Oh, very good. All right, that takes care of the traffic case. Two 6295 SM is the, and your license was revoked at that time? All right, and you acknowledge you gave up all the rights on your place of rights. Let's look at your other case. That may be a little different. There's a formal complaint in this case that alleges that you stole money that belonged to Eric Boggs in the city of Three Rivers, less than $200. Allegation is that this took place at Walmart. Eric Boggs was using the checkout for his groceries. He brought the groceries to his truck. He left $40 cash money at the self-checkout machine. That wasn't very smart. And they went back there and his $40 were gone. And then they used the video to identify you as a guy that took his $40. I'm not sure if that's theft or found money. Anyway, that's the allegation. Have you discussed this at all with him, Mr. Stickley?
This one I have not, Your Honor.
All right. What do you wish to do on this one?
Not guilty. Please.
Not guilty.
All right. I'm going to show a plea of not guilty in that case.
Your Honor, we could probably just set it for a regular pretrial. to
I
begin
think
with.
so. Maybe the prosecutor will take a return of money or something.
Yeah.
Set a pretrial. Are you missing work right now?
No, I work at Amazon, for Amazon. So I work Wednesdays through Saturdays for 10 hours, and then I have Mondays and Tuesdays off.
All right, we'll set
So,
this for Tuesday.
that'd be wonderful. Thank you.
Tuesday, June 9th. June 2nd. I've told this story before. My son Colin had a wallet. It was a turtle wallet. And we were at Walmart in Sturgis for some reason. And he set his wallet down for a kid. It had quite a bit of money in it, about $54. And he went over to some machine to play a game or do something. And he set his wallet down, and I'd gone through the turnstile and I couldn't get back around. By the time I got through the other side, someone stole his turtle wallet with all his money in it. I hope that person feels bad about it, because we were bad and he was sad. It was about 10. Tuesday, June 2nd, 2022. You might bring $40 with you, perhaps the prosecutor will dismiss it. if you can pay restitution to Mr. Fox. So I'll see you in 2 weeks, June 2nd. You can go out to the counter and pay your. Well, let me look here. Let me make sure you don't. I got so many things going on here. I don't see that you owe any money, so that's a good thing. You go out to the counter, you can pay the traffic fine, and we'll do a pretrial on the other case.
Okay.
Ross, here's.
All right, good morning once again, everybody. It's Tuesday here at TCF Live. Nice to have you all here this morning. I hope your Tuesday is not Mondaying you so far. Mine's pretty okay, except for that sad thing that we had to talk about during the pre-show. But that's okay. We got through it. Let's go Lake County, Ohio. Check in with Judge F. Word.
State's understanding at this time. Thank you.
Good morning, Your Honor. I've discussed this matter with Ms. Huff. I believe that a knowing, voluntary, intelligent, guilty plea will be forthcoming.
Ms. Huff, how old are you?
I'm 31.
How far did you go through school?
11th grade?
Are you a U.S. citizen?
Yes, Your Honor.
Are you able to read, write, and understand the English language?
Yes, Your Honor.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, Your Honor.
Have you ever been diagnosed with or treated for any mental illness?
No, Your Honor.
Did you get a copy of the indictment?
Yes, Your Honor.
Do you have any questions about it?
No, I don't, Your Honor.
And it's your intention to plead guilty to all the charges in the indictment?
Yes, Your Honor.
Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Fatika some more, let me know, and I'll give you more time. You understand that?
Yes, Your Honor.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Your Honor.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, Your Honor.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, Your Honor.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, Your Honor.
Do you have any questions about any of these rights?
I do not, Your
Do
Honor.
you still want to plead guilty to these charges?
Yes, Your Honor.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes, Your Honor.
You understand by pleading guilty to the felonies, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, Your Honor.
Both counts 1 and count 2 are aggravated possession of drugs. Both are felonies of the 5th degree. Individually, they each carry a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, Your Honor.
Count 3, possessing drug abuse instruments, is a misdemeanor of the 2nd degree. It carries with it a maximum jail sentence of 90 days and a maximum fine of $750. Do you understand that?
Yes, Your Honor.
If you plead guilty to the forfeiture specifications in each of these counts, and you're voluntarily giving up the items listed in each count, do you understand that?
Yes, Your Honor.
Now, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term of 24 months and a maximum fine of $5,750. Do you understand that?
Yes, Your Honor.
Any questions about the penalties?
No, Your Honor.
Are you presently on post-release control to the parole authority?
No, Your Honor.
Do you understand your guilty plea may result in a driver's license suspension of between 6 months and 5 years?
Yes, Your Honor.
Do you understand your felony conviction will prevent you from owning or possessing a firearm?
Yes, Your Honor.
Do you understand if a prison sentence is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority?
Yes, Your Honor.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, Your Honor.
Do you understand if your violation of post-release control is a new felony, you could get an additional consecutive prison sentence for the violation?
Yes, Your Honor.
If that were to happen, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, Your Honor.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes, Your Honor.
I could place you on community control for up to 5 years, but if you violate the conditions, I could send you to prison for 24 months. Do you understand that?
Yes, Your Honor.
Has anybody promised you that I would be lenient on you just because you're pleading guilty?
No, Your Honor.
Has anybody promised you what I will sentence you to in this case?
No, Your Honor.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, Your Honor.
Have you had enough time to talk to Mr. Fatika before pleading guilty today?
Yes, Your Honor.
Has he discussed everything about your case and answered all of your questions?
Yes, Your Honor.
Are you satisfied with the advice he has given you?
Yes, Your Honor.
Have you been threatened or coerced in any way to plead guilty today?
No, Your Honor.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
All right, Ms. Cutts, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on January 16th of 2025, shortly after 1:30 p.m., Lake County Sheriff's Office deputy observed a vehicle, conducted a traffic stop on that vehicle at the intersection of Fairport Nursery Road and Blaze Nemeth Road in Painesville Township, Lake County, Ohio. There were 2 individuals in the vehicle, the driver being a male, James Humberson, and the front seat passenger being a female, Tanya Huff, the defendant. The driver was found to have a misdemeanor warrant from Mentor Police Department, so he was taken into custody. The defendant had a suspended license, so was unable to take the vehicle. During an inventory search of the vehicle, multiple items were found to include in the front passenger side seat a black wallet with a syringe with a clear substance, as well as the pouch on the back of the front passenger seat has a syringe with a dark brown substance. Both syringes were sent to the Lake County Crime Lab. They both contain methamphetamine, a Schedule II controlled substance. Each was swabbed, and a comparison was made to the defendant's DNA. Her DNA was found to be consistent on both of those syringes. All of this occurring in Lake County, Ohio, and that would have been the state's evidence.
Thank you, Mr. Fatika. Anything to add to those facts?
No, thank you, Your Honor.
Ms. Hupp, did you hear what Ms. Cutts said the facts would show if the case went to trial?
Yes, Your Honor.
Are those facts true?
Yes, Your Honor.
What is your plea to count 1, aggravated possession of drugs, a felony 5?
Guilty, Your Honor.
What is your plea to count 2, aggravated possession of drugs, a felony 5?
Guilty, Your Honor.
What is your plea to count 3, possessing drug abuse instruments, a misdemeanor 2?
Guilty, Your Honor.
And what is your plea to each of the 3 forfeiture specifications on these counts?
Guilty, Your Honor.
Mr. Fatika? This is your secret.
Your Honor, proceed to plead guilty of judgment entry, and witness the defendant sign a document in court for constitutional.
Ms. Huff, is this your signature on the written plea of guilty?
Yes, Your Honor.
Did you sign it voluntarily?
Yes, Your Honor.
Do you want me to accept your written plea of guilty?
Please, Your Honor.
I'll accept the written plea of guilty. Defendant was present. Mr. Fatika advised of all of her rights, made a no intelligent voluntary waiver. She understands the nature of the charge, the consequence of her guilty plea, and the maximum penalty for it to be knowing, intelligent, voluntary. I will accept her plea of guilty and find her guilty of count 1, aggravated possession of drugs, a felony 5, count 2, aggravated possession of drugs, a felony 5, count 3, possessing drug abuse instruments, a misdemeanor 2, and each of the forfeiture specifications. I'll refer this for a pre-sentence report and a drug and alcohol evaluation. The sentencing will be June 24 at 1:30 p.m. and the bond is revoked. Anything else, Ms. Cutts?
No, thank you, Your Honor.
Mr. Fatika?
No, thank you, Your Honor.
Greetings and salutations once again, everybody. TCF Live on a Tuesday. It's nice to have you here. Slower start in the courts this morning. Some look like they're getting ready to get going here soon, but not a whole lot going on at the moment. But we do still have Judge Middleton, so we're going to go back there for a little bit.
Good morning, sir. Are you George Henry Markin?
Yes, sir.
You got a ticket in White Pigeon on May 1st. Must be they wrote a lot of tickets that day for driving with a suspended license. You heard me talk about that. We have a lot of these. And in your case, let's take a look. Oops. They allege that you were driving 131 in Dickinson Road in the village with a suspended license, driving a Chevy. Driving suspended, as you heard me say, is a misdemeanor. It's punishable by up to 93 days in jail and fine of up to $500. Your license is actually revoked because of a lot of old baggage on here. Despite that, the White Pigeon Village attorney is willing to dismiss this charge for a plea to allowing another to violate the motor vehicle code. I'm not sure the county prosecutor would have done that. But the White Pigeon attorney is willing to dismiss the driving suspended charge. If you plead guilty to a charge called allowing another to violate the motor vehicle code, that one carries no points, doesn't go on your driving record, and won't affect your ability to keep or maintain your license. It is a misdemeanor, punishable by up to 90 days in jail and a fine of up to $100. The normal fine is $100 plus $125 cost. Are you willing to plead to that lesser charge of allowing another to violate the motor vehicle code?
Yes, sir.
That's a pretty generous offer. As I said, I'm not sure the county would do it. You've got a lot of baggage on there. And you know you're not supposed to be driving. But White Pigeon's willing to do that. And again, we don't seem to have any unpaid fines or costs. How are you doing with your pre-trials, Mr. George?
We had one. We had one that was marked in custody, but apparently he's not in custody. Okay.
Where were you going?
I was going home. I just left McDonald's, just got stopped at McDonald's, got something to eat, was headed home.
And your license was suspended at that time? Revoked? I joke about this periodically. I was going to do a study about how many people are coming from McDonald's when they get either a ticket or we get a lot of drunk driving arrests at night when people are going to McDonald's. They should have just stayed home. Well, you just live outside of town a little bit. And that is the nearest McDonald's. You live out in the Purgatory area.
Yes, sir.
All right. So Peter put nice labels on all those drawers down there, which makes my life much easier. Whose car were you driving?
The stepsons.
Oh, same thing. They can get in trouble for letting you drive a car. Which is the essence of this charge, allowing another to violate the motor vehicle code. In this case, you're allowing yourself to do it, but your son could actually have gotten the same ticket, your stepson, for letting you use his car. Anyway, I'm just gonna do the same thing I did with the last guy, $100 fine, $125 in costs, for a total of $225. Can you pay that today or any
I
time?
can pay it by Friday.
I'll give you 30 days. I'll make it due by June 20th. You can pay with a credit card. You can come in here and pay with green cash. You can mail in a certified check or money order. When I was 16, I got a ticket for driving without my license in my possession. I'd gone swimming or something with my, at that time, my old girlfriend that I knew in high school, and she put my wallet in her purse. And she went on vacation and she drove to New York with her family with my wallet. So I got stopped. I didn't have my driver's license. And I came in here and paid a ticket right there, that window, in 1972, when the district court was there. So you can pay your ticket at the same place I paid mine. I believe it was $35. Which is a lot of money for a 16-year-old kid with a part-time job. $225 by June 20th. It's on the inside. There's instructions on how to pay it.
Okay.
You can't drive. You've got lots of bad.
I know, I'm
So
financially,
you should get
but
your
I'm,
mind around that. Here's the envelope you can use. I lost the bailiff. You can come here and get this. You can use this.
you want to come get it.
And then are you free to go? All right. Michael Mercer. Good morning, sir.
Morning.
Better wastebasket. I just throw stuff on the floor here. So far, we haven't had any interpreter cases. They really slow us down. Takes 3 times as long to do a case to a translator. Slow enough as it is. All right, you're Michael Robert Mercer.
Yes, sir.
I believe we've met in the past, but I'm Judge Middleton. I need to identify you for the record. Allegation here is that you made an assault or assault and battery upon Janet Mercer, your spouse. They charged 2 counts of that. It's alleged to have occurred May 8th in the village of Constantine. Domestic violence is a misdemeanor. It's punishable by up to 93 days in jail or fine of up to $500. All right. Mr. Stickley, what's your thought on this one?
I would highly recommend he enter a plea of not guilty and we can get him appointed an attorney.
The public defender is recommending that you plead not guilty and I get a lawyer to help you with this. Is that acceptable to you?
Yes, sir.
Now, according to this, you slap your wife quite frequently. At least that's what the allegation is, according to her family and to her. And may also be some cognitive things going on. Now, there's a no contact provision. So are you out of the house?
Yes, sir.
Where are you staying?
With my daughter.
What town is that in?
It's outside of Three Rivers.
That's you?
Yes.
All right. You're not guilty, appoint an attorney. It's probably too late. All right, I wish Judge PM stole my calendar. Or could you bring me one of the county calendars? I had one in there and I got lost. I think we can still set this for June 5th. Those Fridays have become so busy. All right, I'm gonna send you out to the office. They're gonna appoint a lawyer for you. And I want you to call your lawyer, make an appointment to discuss this matter with them. I didn't see that you owed any money. Let me look at something here. But right now, you're out of your house. Who owns the house?
We both do.
All right, so that's.
We're married.
How long you been married?
40 years.
All right, so yeah, there's a lot going on here. Are you getting any medical treatment?
No, just,
You're not?
I mean, I wanted person. Okay. So,
Well, there's, as you know, more than one Mike Mercer. And you've got a little baggage, but not much. I haven't seen you since I was prosecutor 20 years ago. But you go out to the counter, we'll get an attorney to help you with this. And I'll see you on June 5th at 8:30.
Okay.
So you go to the court officer. Who's that? Is he at the jail?
Alrighty, friends, that was Defendant Mercer. Let's go to Florida and see what's going on with Judge Mercer.
Miss Hayes, you're here because you've been accused of 1 count of battery and 1 count of petty theft. Ma'am, there is probable cause in the complaint for these 2 charges. I've also looked at your criminal history, Miss Hayes, which I see I wouldn't say a long criminal history, but it's kind of a mediocre criminal history. It's certainly not little. Several prior arrests, it appears, but I think you're entitled to a bond as far as I can tell, Ms. Hayes. Please listen to Mr. McDaniel and Mr. Mitchell, then I'll address your bond or your release status. Mr. McDaniel, anything on behalf of Ms. Hayes?
Your Honor, Ms. Hayes is disabled. We're just gonna ask the court for, maybe a conditional release. This is a transient person, I think, that's staying, in a car close to her house there, with a dog. And, she obviously can stay away from the person since the person don't even live in the neighborhood. So we just asked for maybe a conditional release.
Let me take a look at one, goes two. That's a VOP. So it's 2 arrests, 3 arrests, 4, 5, 6. I'm trying to see what we're getting something more recent. So, Mr. Mitchell, you're looking at about at least a half dozen, probably closer to 10 arrests. But in her favor, the last arrest would have been 2005, according to this rap sheet I've got. So 20 years ago is the last time she's been in trouble. Ms. Hayes, has it been about 20 years or at least 20 years since you've been in trouble, ma'am?
Yes, sir.
Okay, that's helpful. Mr. Mitchell,
Nothing from the state.
what's your position on the request for a conditional release?
No objection, given what you just told
Yeah,
me.
Miss Hayes, this is one of those cases I had written down a tentative bond, but Mr. McDaniels kind of give me some additional information or made me look closer at the criminal history. So what I'm gonna do is I'm gonna let you pick between a bond and a conditional release, ma'am. If you want to post the bond is $2,500 per count. Some people prefer a bond. I am going to offer you a conditional release because you haven't been in trouble in so long. Either way, you have a condition of no contact with the alleged victim. Ms. Hayes, do you have any questions, ma'am, about the choice between bond and conditional release?
No, sir.
And which one do you want to choose?
The conditional release.
So let me talk to your daughter then. So ma'am, what that means is that the jail will let her get dressed in regular clothes. They'll bring her to the courthouse because that's where the conditional release office is at. She'll meet with the conditional release officer downstairs and she'll be free to leave after that once they go over everything with her and give her a chance to ask questions. That process takes 10 minutes maybe. And the conditional release office is inside the county judge's office down here on the east side of the courthouse. Are you going to be able to pick her up? Your daughter says she's got your transportation covered. She'll be here to pick you up. Ma'am, that's 30 to 45 minutes from now is when they'll have her here. Okay. Your daughter says she'll be here to pick you up. Ms. Hayes, do you have any questions?
No, thank you.
Yes, ma'am. We're also going to give you a notice for your court date, which would be
We're still in the cutoff, the first.
June 1st. June 1st at 9 a.m. will be your court date, Ms. Hayes. You'll get that notice, ma'am, and they'll give you a copy of that in writing, okay?
Okay.
Have a good day.
You too.
When's that cutoff? Is it Friday?
Thursday.
Next Monday?
Ma'am, thank you. We have Jessica Rutherford. Ms. Rutherford, good morning. Ms. Rutherford, you're here for first appearance accused of 1 count of domestic battery, ma'am. There is probable cause in the complaint. Ms. Rutherford, the criminal history I've got shows no prior history, so it appears that you've never been arrested or charged with a crime anywhere. Is that accurate?
That I'm aware of, yes, sir.
Well, you would be aware if you'd been arrested or charged with a crime, most likely. Have you ever been arrested anywhere?
No, sir.
I don't see anything. Okay. The problem is the living situation. So I'm going to put a condition of no contact between you and the alleged victim, Miss Neal. So the complaint says you reside together. Is that accurate?
Yes, sir.
So do you have somewhere else you can live on a temporary basis other than where Miss Neal lives?
Your Honor, they have the piece of property there is about a little over 2 acres, and there's 2 houses on the property divided by trees and probably about 100 yards of trees and stuff. And she's advised me that she'll live on the other home there on the property if courts.
Maybe. Miss Rutherford, thank you, Mr. McDaniel. Miss Rutherford, let me ask you a couple of questions about that. Those are always difficult situations. Do they have a common driveway?
Yes, sir.
Do both homes have electricity?
They both have their own separate, yes.
They have separate driveways?
Separate driveways and both separate power, electricity, and water.
So before yesterday, you both lived in one of the home. Who lived in the other home?
Nobody. I hadn't rented it out, sir.
Who owns the properties?
I own the properties.
Do you own both homes?
Yes, sir.
And you and she lived in one and the other one's just vacant?
Yes, sir.
Okay, Mr. Mitchell, any questions about that living situation or any input?
Not at this time, Your Honor.
Okay, so Miss Rutherford, you need to understand, no contact means no contact, and that's what's going to be in place, at least for now. Now, that may be modified in the future at some point. For now, you need to assume it's going to last. So no contact means you can't talk to her, you can't text her, you can't communicate with her, you can't do it electronically on the telephone, no contact at all. And you need to understand it, if you violate that and there's credible evidence you violated that, then you can go to jail with no bond and just be
Yes,
there.
sir.
You could be there for weeks, possibly even months. So you've got to take the no contact seriously. So before I give you a conditional release and let you go back on that property, I need to make sure you understand that. Is there
Yes, sir.
going to be any problem you stand away from each other, even if you're on that same property?
No, sir.
Okay, so what I'm going to do is let you pick between the bond and the conditional release. Your bond will be $2,500 cash or surety. I am going to offer you a conditional release because of your lack of criminal history, but you've got a condition of no contact with her or that home. You cannot go down that driveway. You cannot go in the area of that home. How far apart are the two homes?
I looked at it, it's probably about 300 to 500 yards, feet apart,
Okay.
probably about, there's
Okay,
trees all in between it.
You cannot go within 100 feet of that home. The only exception to that is contacting law enforcement and going with them to get your clothing out of there. One time, they'll do that for you one time to get clothing and medicine, stuff like that. Other than that, you can't go in that home at all. Now, if it gets modified in the future, possibly at your court date, we'll talk about that if she wants contact and if you want contact, but for the time being, no contact at all. Do you understand your choice between bond and release?
Yes, sir. Go with the conditional release, please.
Okay, so someone just came, sir, are you here for a first appearance case? Can we tell what case, is it this case or a different one? Okay, so we had a gentleman come in the courtroom. I want to make sure he wasn't here on your case. So what's going to happen, Ms. Rutherford, is I'm going to grant you the conditional release. Jail's going to let you use the phone. They're going to let you get dressed in your regular clothes. They're going to bring you to the courthouse. When you get here, you'll meet with a conditional release officer. The conditional release officer will go over the release with you and you'll be free to leave. You'll be given a notice for your court date, which should be June 1st. Is that right?
Yes.
June 1st at 9 a.m. will be your court date. And then remember the condition, no contact, at least for the time being. Ms. Rutherford, do you have any questions?
No, sir.
Wish you the best, ma'am. You'll use the phone shortly for transportation purposes. Sir, if you tell me what case you're here on, I'll call it next.
We have a Hispanic case, Your Honor.
I do.
No, we have-
Yeah, we have Mr. Ricardo, we have Esau, Rojas, Lopez. And I want to tell him who's here if you want him to know that you're here. Do you want him to know that you're here? Okay, so Mr. Ricardo, good morning. If you'd introduce yourself to Mr. Rojas Lopez and make sure he can see and hear you.
Very well, Your Honor. Good morning. Señor Rojas López, mi nombre es Jordani Ricardo, intérprete para que se pueda comunicar con el juez. ¿Me ve y me escucha?
Sí.
He can hear me and see me, Your Honor.
All right, good morning, Mr. Rojas. Mr. Skurlock is here on your behalf.
Buenos días, señor Rojas. El señor Skurlock está aquí a favor suyo.
You're here because you've been accused of one count of driving with no valid driver's license.
Usted está aquí porque tiene un cargo de manejar sin licencia de conducir válida.
You also have a detainer placed on you from the United States Immigration Service.
También tiene una orden de retención de parte del Servicio de Inmigración de Estados Unidos.
I have read the complaint. There is probable cause for the charge.
Leí la denuncia y hay causa probable para el cargo.
I've also looked at your criminal history, which shows no prior criminal history.
También revisé sus antecedentes penales que muestra que no tiene antecedentes penales.
So I'm appointing Mr. McDaniel's office to represent you. Please listen to your attorney.
Entonces le voy a asignar a su abogado, el señor McDaniel, para que lo represente. Por favor, escuche a su abogado.
Your Honor, I spoke to Mr. Lopez. He's going to plead of no contest to the charge as listed.
Su señoría, hablé con el señor López. Él se va a declarar no me opongo ante los cargos, tal y cual se le acusa.
Sentenced to 2 days in the county jail, credit for 2 days.
Se le condenará a 2 días en la cárcel del condado con crédito por 2 días.
We have $400 fine, which would be a civil judgment he does not have to pay.
Tendrá una multa de $400 que será un fallo civil. Él no tiene que pagar.
Waived his right to a jury trial and call witnesses.
Ha renunciado a un juicio con un jurado y a llamar a testigos.
Understands any plea can be used against him in the immigration court.
Entiende que cualquier acuerdo en un caso penal se puede usar en su contra en el Tribunal de Inmigración.
He understands that there's an ICE hold for him, immigration, and they'll pick him up within 48 hours.
Él entiende que tiene una orden de retención de parte de inmigración y que lo recogerán en un plazo de 48 horas.
They'll resolve this case today.
Pero esto resolvería su caso.
Mr. McDaniel, I heard just a part of something about the fine. What did you say about the fine?
Then it'd be a civil judgment, because he was asking me about how to pay it and all. I'm trying to let him know that it's a civil judgment. He doesn't need to pay it. It'll go against his credit rating.
Y señor McDaniel, usted dijo algo acerca de su multa que no entendí. ¿Qué fue lo que dijo? O él me estaba explicando que cómo pagar y yo le expliqué que es un fallo civil, que no tiene que pagarlo, que sencillamente le afectaría su crédito.
Mr. Rojas Lopez, I'm sure Mr. McDaniel told you that your driver's license rights in Florida may be suspended also if you don't pay it.
Y señor Rojas López, también estoy seguro que su abogado, el señor McDaniel, le dijo que su derecho a conducir o a sacar una licencia en la Florida también se le pudiera suspender si es que no paga.
Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor.
Señor Mitchell, ¿está de acuerdo el Estado? Lo está su señoría.
Mr. Rojas, did you hear that? Mr. Rojas, did you hear that agreement?
Señor Rojas, ¿escuchó usted el acuerdo?
Sí.
Yes.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
No.
No.
Is that the plea you would like to enter?
¿Es ese el acuerdo que desea aceptar?
Sobre pagar si se me puede, sí.
To pay if, yes.
That is what you want to do, correct?
Este es el acuerdo que desea aceptar, ¿correcto?
Sí.
Yes.
Mr. Rojas Lopez, I'm going to accept your plea of no contest to the charge of driving with no valid driver's license.
Señor Rojas López, acepto su declaración de no me opongo ante el cargo de manejar sin licencia de conducir válida.
I'm going to withhold adjudication of guilt and sentence you to 2 days in jail with 2 days credit.
Le suspendo el fallo de culpabilidad y lo condeno a 2 días en la cárcel con crédito por 2 días.
I'm imposing the court costs and fines in the amount of $400.
Le impongo multas y costas del tribunal por $400.
If those court costs and fines aren't paid within 60 days, they'll become a civil judgment against you.
Si no paga esas multas y costas en un plazo de 60 días, se convertirían en un fallo civil en su contra.
Immigration will be notified this morning to pick you up, and under the agreement with the state, they have 48 hours to pick you up.
A inmigración se le notificará esta mañana para que lo recojan y bajo el acuerdo con el Estado tienen 48 horas para recogerlo.
Do you have any questions?
¿Tiene alguna pregunta?
No.
No.
Mr. Scurlock, any questions?
So what's this mean? That he has no bond, or that he paid $400, or what?
Why don't you come on up? I want to make sure he can hear you. Come on up. And I want you to speak in short fragments so the translator, so the interpreter can make sure he understands what you're saying. How's his English? You're his employer, I'm assuming?
What? No, I just know it. And you
So
know,
just speak in short sentences and
Okay.
and then stop, and we'll get a translator. Mr. Ricardo will translate for you.
what does this mean? That he will be, he can get out on bond, or he has to stay in?
¿Qué significa esto? ¿Que él puede salir bajo fianza o que se tiene que quedar dentro?
What it means is he has resolved his state charges. He's through with this case here.
Eso significa que ya resolvió sus cargos estatales, ya terminó con su caso aquí.
He has a $400 fine that will go to a collection agency if he doesn't pay.
Tiene una multa de $400 que se trasladará a una agencia de colecciones si es que no paga.
And it also will cause a hold on a Florida driver's license if it's not paid.
Correct.
Y también, si no paga, se le retendría su posibilidad de sacar licencia de conducir en la Florida.
The United States Immigration Service has 48 hours from when they're notified to pick him up.
Okay.
El Servicio de Inmigración de Estados Unidos tiene 48 horas para recogerlo desde que se les notifica.
When they pick him up, he'll be taken to an immigration facility and go through that process.
Cuando lo recojan o si lo recogen, pasará a una instalación de inmigración y tendrá que pasar por ese proceso con ellos.
And an immigration judge will be the one to eventually decide if he's deported or not.
Okay.
Y un juez de inmigración es el que eventualmente va a decidir si lo deportan o no.
Lately, every case they put a detainer on for months, they've been picking up within the 48 hours.
A todos los casos, por meses ya, siempre que le ponen una orden de retención, los han estado recogiendo en un plazo de 48 horas.
But if for some reason they don't pick him up within 48 hours, he's entitled to be released.
Pero si por alguna razón no lo recogen en un plazo de 48 horas, él tiene derecho a que lo dejen salir.
Do you have any other questions?
¿Alguna otra pregunta?
He's in the process with an immigration lawyer. And they've been contacted, and I'm just here on his behalf just to see if that comes into court today, or does he need just wait for immigration to pick him up, or?
Él tiene un abogado de inmigración y nos comunicamos con él. Yo estoy aquí hoy para preguntar si eso entra en juego hoy o si él tiene que sencillamente esperar a que inmigración lo recoja o cómo.
No, it has nothing to do with today.
Okay.
Eso no tiene nada que ver con hoy.
Because under federal law, you have to get permission upon arrival into the country or before coming, not try to get it after you get here.
I understand.
Porque bajo la ley federal hay que pedir permiso para entrar en el país antes de entrar o cuando uno va viniendo, no después que
It
uno
may
ya
or may
llegó.
not be, it may or may not be important when he gets to immigration court.
Puede que sea o que no sea importante cuando sí vaya al tribunal de inmigración.
Any other questions?
¿Otra pregunta?
Thank you for coming, sir.
Gracias por-
Jerry. Yeah. This is John McDaniel here.
Hey, John.
How you doing? This is a longtime employer of mine when I was a kid growing up. If you would give Jake your phone number, Jerry, I'll give you a call a little bit later.
Okay. Okay.
Jake, send it to me and I'll talk to you about it.
Okay. Thank you.
You're welcome.
Yeah, right here. Wait, you want me to give?
He wants my phone number.
He wants.
Yeah.
Okay. All right.
Just
Yeah.
text me Jerry's phone number if you would.
Okay.
Mr. Rojas Lopez, do you have any questions, sir?
Señor Rojas López, ¿tiene usted alguna pregunta?
No, señor.
No, sir.
Have a good day, sir.
Que tenga buen día, señor.
We have Connie Mott next.
And Your Honor, may I be excused?
Yes, sir. Thank you, Mr. Ricardo.
Thank you, Your Honor.
I saw Mr. Miller on there for a second.
He's here for Mr. Hodges.
Okay, Mr. Miller, we'll call that case in just a second. I have two short first appearances left. Mr. Miller, if you're still there. Ms. Mott, good morning. You're here for a violation of state probation, ma'am. Ma'am, there's a warrant, a no bond warrant signed by the circuit judge. Ms. Mott, what I'm going to do this morning is I want to arraign you, which means I want to appoint you a lawyer in this case if you would like to have one appointed. Would you like to have an attorney appointed to represent you, ma'am?
Yes, sir, I would.
I'm going to appoint the public defender's officer to represent you, Ms. Mott. Listen to Mr. McDaniel, then I'll see if you have any questions.
Your Honor, we're going to plead not guilty. Yes, to sit this in the June 4th court docket and advise, there'll be an attorney to come talk to her prior to that hearing.
Thank you. Mr. Mitchell, anything? Thank you. So Ms. Mott, June 4th will be your court date and you'll see your attorney before that court date. Any questions, ma'am?
No, sir, not at all. Thank you kindly.
Yes, ma'am. Have a good day.
Yes, sir, you
And
too.
lastly, on first appearance list, lastly, we have Patricia Butler. Ms. Butler, good morning. Ms. Butler, you're here in case number, actually, I don't have a case number. You have a hold out of Holmes County. It looks like we held you, a judge held you for 7 days, ma'am. See if Holmes County was going to get a violation of probation warrant. I have a document in front of me, ma'am, which is a no bond violation of probation warrant signed by Judge Roberts. So ma'am, you do have a violation of probation warrant. It does have no bond. I think you probably were anticipating this. You've got your local charges. In addition to those, you have the no bond warrant out of Holmes County, which you kind of were expecting. Ms. Butler, do you have any questions, ma'am?
No, sir.
Ms. Butler, wish you the best, ma'am.
Thank you.
And then we have Mr. Miller. I apologize, Mr. Miller. I saw you flash up there. I meant to call your case earlier and I didn't.
That's okay,
So
Your
that
Honor.
case is State versus Jacob Hodges. While Mr. Hodges is coming up, Mr. McDaniel, anything else on behalf of the public defender's office, sir?
No, Your Honor.
And from the jail, anything else, Officer Whitakerson?
No, sir, that's it.
Mr. Mitchell, anything else you need the jail for?
Nothing as it relates to first appearances, Your Honor.
All right, thank y'all at the jail and we'll see you tomorrow. This is State of Florida versus Jacob Mitchell Hodges, case 25483 CT. Mr. Hodges is present. Mr. Dustin Miller is his attorney. Mr. Miller's appearing remotely, and Mr. Goodson's here with the probation office. And Mr. Miller, I know a little bit about this from talking to Mr. Goodson. I think there's some completion, some progress, or maybe finished probation. I'm really not sure. Mr. Miller, where do we stand, sir?
Your Honor, I got to be honest with you. I found out this morning from ASA Mitchell that we had a hearing. So that's why I'm not in a court appropriate shirt.
I don't think it's a hearing. I think he's completed some type of program, and we're just trying to see if he's stood probation or not. So Mr. Goodson can probably fill us all in.
Okay.
Yes, sir. Thank you. Mr. Hodges anyways, he got put on probation January 23rd. With several conditions for the charge of DUI. One of those being, of course, to pay the court cost. He did pay the court cost in full. He was required to complete a 90-day inpatient treatment program and also the aftercare portion of that program and provide proof to the court. I do have and Mr. Hodges is here, I have a certificate of completion for the program. So Mr. Hodges was required to report to the program on February 16th of 26, excuse me. And January 24th, January 26th, he reported to Twin Lakes Recovery Center. He stayed there until February the 16th. February 16th, he transitioned to Carter Treatment Center in Alpharetta, Georgia, and he was completed both programs on May the 11th of 26. A condition of his probation was possible termination after 90 days inpatient treatment if all conditions are met. I did receive an email from the coordinator, Hillary Boltrus, stating that Mr. Hodges was required to work for at least 1 hour a day. He was in the program over 90 days, so he complied with, according to this email, he participated, he volunteered an hour a day cleaning, whatever they required him to do. He did that. She said he was good help, so he would have met the 50-hour condition based upon this email I received from the coordinator. COS was waived. I guess the only thing he has not completed, and I talked to Mr. Hodges about this on the 12th, was he was required to go to a DUI school. He informed me that he was going to try to get enrolled in DUI school. I'm not sure if he did or not yet. My understanding from Mr. Hodges is he's going to stay in Alpharetta, Georgia. His daddy lives in Donaldsonville, and he has 2 jobs. So everything's complied with except the DUI school, and I'm not sure where we are as far as that. I'll let Mr. Hodges address that.
Let me ask a question. The offer was 90 days in jail. Mr. Miller and Mr. Mitchell agreed and presented me an alternative offer of probation with a condition he'd do at least 90 days inpatient program.
Inpatient plus aftercare.
Plus aftercare. But the agreement wasn't that he would, the only reason the probation was there was just because it had to be probation done. No one ever planned on him being on probation once he completed the program, correct?
That's my understanding.
I think that's correct.
That's my understanding too. Okay, so Mr. Miller, the only question I have then is, has he done at least 90 days in an inpatient program? Are these inpatient programs we're talking about?
Yes, sir. According to that letter right there.
Mr. Hodges?
You have a letter from her?
Okay, so he's done everything he's supposed to do except the DUI school, which is a condition to get his license back.
Yes, sir.
Okay. Mr. Miller, I think so. We're just here, I think because the plea had a condition that him get proof, Mr. Miller, and that's what he's doing here today. So, Mr. Miller, anything else that you want to make sure I'm aware of?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
So basically, we're just here to terminate his probation because we added that solely to make sure he completed the program, and now he's done that.
Yes, sir.
Is that your understanding, Mr. Hodges?
Yes, sir, Your Honor.
So I'm not going to keep you on probation when the whole reason the probation was there was just to give some teeth to the if you didn't stay the 90 days, which you did. So thank you for doing that. So you completed the sentence as far as I'm concerned. You need to understand that you still may have to do the DUI school to get your license back, but that's not going to keep you on probation.
Yes,
probation was added to make sure you stayed in the program, which you did.
Yes, sir.
So unless there's objection from the state, I'm going to terminate this supervision.
No objection.
Mr. Miller, that's what you're wanting to do, correct?
It is, Your Honor.
So I'm going to terminate your supervision. You've completed everything that was asked of you, Mr. Hodges. You're through with this case. You may have additional things the state of Florida makes you do to get a license back,
Yes,
such
sir.
as DUI school, but as far as probation goes, you're no longer on probation. Do you have any questions?
No, sir. And I knew that I had to do the DUI school.
We can't do it while you're there, though.
No, sir.
Yeah.
But I can do it on Zoom in Georgia.
That's good for us to know that. So, but
They
that's for
do
Georgia.
those on Zoom now in Georgia.
Well, I don't know the Florida. We have that option.
I understand Georgia does.
Okay, good. Good for you. This is your father?
Yes, sir.
Sir, do you have any questions?
No, sir.
Any questions at all, Mr. Hodges?
No, sir, but it was the best decision I made in my life.
Well, you know, I remember the case.
Yes, sir.
I was pretty adamant that you needed jail time. Mr. Miller did an excellent job of convincing first Mr. Mitchell, and then they both convinced me to give you a shot at this. So I'm glad I did. I'm glad you went. I'm glad you completed it.
I remember, and maybe I need to go because he's muscled up now, but I remember Mr. Hodges, when he came in here and got put on probation, it looks like a totally 100% physically different person.
Yes, sir. I got through it. I got through the withdrawals and all that, and it's the best decision I ever made.
I'm
I
glad
got
to hear
2
that.
jobs up there now.
Well, good. And you're gonna live where?
It's Alpharetta was where the Carter Center was at. I'm going to live in Dawsonville, Georgia.
Yeah, I think I got a speeding ticket in Alpharetta one time on the way to law school. I don't go through there no more.
Yeah.
But thank you very much, Mr. Hodges. I wish you the best, but your probation is terminated.
Thank you, Your Honor.
Thank you, Mr. Miller, for appearing today.
Thank you, Your Honor, and congratulations, Mr. Hodges.
Mr. Mitchell, anything else?
No, Your Honor.
Don, anything else?
All righty. Good morning once again, everybody. It is now hour 2 of TCF Live. Time just flies and flies and flies. Okie dokie. Tot, I didn't thank you earlier for gifting a membership. Apologies for that. Thank you so much. I do appreciate that. Let's, sidebar tonight, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel. Episode, what are we on? 68 tonight? Yeah, 68. That's a lot of episodes for a show that was the idea of channel members, not of me. That's the beauty of that show. It is it's what the community wanted, so makes it very cool. So do join us right here tonight, 8 p.m. Eastern, 5 Pacific. Let's go Michigan. Judge McNally.
First name Daryl, last name Brian.
Where you been?
I was displaced. I ended up losing my house roughly June of last year. And I ended up staying with my brother in Ohio. What happened is I forwarded my address.
Slow down. Slow down.
Okay.
I'm gonna go ahead and arraign you. You didn't show up on August the 28th, the 25th. This is the case assigned to Judge Hesson. It was an operating while impaired. She was awful kind to you too.
Yes.
And the charge here now is that you failed to pay $598.60, which I guess with the warrant fee now should be $35 more. Is that right, Lisa?
The balance on the A case is $598.60 and the B case is $296.
So you're charged with failure to pay $598 on the A case. If I find you didn't pay and your failure to pay was not without your fault, you could get 93 days with credit for 1 day served. On the other, I'm sorry, you said $296 on the other?
That's correct.
And you're charged with failure to pay $296 on the B file. You could be incarcerated 1 day for every $10 owed on that. So you could get 30 days on that. If you can satisfy that in full by payment, full by serving the jail term, or in part by payment and in part by serving the jail term. Do you understand that?
Yes, sir.
Did you sign an advice of rights form today?
No, sir.
You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to a hearing. At that hearing, they have to prove you guilty by a preponderance of the evidence. That is that you failed to pay and your failure to pay was not without your fault. And you have the right to remain silent at that hearing, to bring in your own witnesses at that hearing, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing. Do you understand that?
Yes,
You have the right to a lawyer. If you want one, I'll give you one. Would you like a lawyer?
yes, sir. Can I ask a question?
It depends if it's a question. You should really talk about it with your lawyer. So I'll give you a lawyer. Can't just come walking in here 10 months later. I mean, maybe other judges are more understanding. I'm not one of them.
I understand. I just want to explain.
No,
Okay,
I want to hear it.
yes, sir.
9 months later, I guess. I don't get it. I don't understand it. I never have, never will. It's so incredibly disrespectful. You might as well bring in a flag that says, I have no respect for the greatest branch of government, the greatest country in the world. Go out, meet with your lawyer, come back in front of me, okay? Ralston, Lawrence Dwayne Ralston, 263-239-307. Yes, sir. Come on up here. I also have Kenneth Lee Ralston, 260-239-310.
My brother, he's here with.
All right, come on up. All right, sir, your name?
I'm Lawrence and this is Kenneth.
You got to tell me your full name.
Lawrence Dwayne Ralston,
Your name.
Kenneth Lee Ralston.
All right, so you guys are charged with taking possession over the limit of walleye. It's this pike perch. You were 16 over limit according to them. This is a misdemeanor. It is punishable by up to $100 fines, 90 days jail, costs or all those, and there would be $160 in conservation fees, $10 a fish on your case, Lawrence, and on yours, Kenneth, it would be 17 fish or $170. Do you each of you understand that, sir?
Yes, sir.
You understand
Yes,
that,
sir.
sir? Did you sign, read, and understand an advice or rights form, Kenneth Ralston?
Yes, sir.
All right. Did you, Lawrence Ralston?
Yes, sir, I did.
All right. If you plead guilty, you'll be giving up all the rights on that advice or rights, and we're not going to have a hearing or a trial. Do you understand that, Kenneth?
Yes, sir.
Ralph? I mean, Lawrence?
Yes, sir.
All right. Each of you have the right to a lawyer. I'll be happy to provide you with one at public expense. Would you like a lawyer, Lawrence?
No, sir.
Kenneth?
No, sir.
I'm entering a not guilty plea for you. Okay, gentlemen? I'm gonna give you a $100 personal bond. You don't have to post any money. I'm gonna send you to the prosecutor. You can talk to her and see what she'll work out for you.
You entered a what for?
Not guilty plea.
Oh, we want to plead.
No, you don't. No, you don't. No, you don't. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm sure you'll make out at least. You can't do worse. If you plead guilty, I'm taking the plea. If you go talk to her, maybe you can get a civil infraction or something, okay?
Yes, sir.
So go talk to her
Can we talk to her today tonight?
right now.
Okay.
She should be in the building. I had to schedule things late. I had an appointment this morning, so they were told to be in here at 9:45 and she should be here.
Let's see.
Okay, thank you.
Thank you, sir.
Have a good
Thank
day.
you, Your Honor.
We'll see you back here. Jose Javier Medina Machi, Q60240451, and Manuel Medina Machin, 260240450. Good morning, Ms. Villarreal. Pleasure again. How are you?
I've been well, thank you.
Your name?
Bill, certified court interpreter.
I'm gonna ask you to raise your right hand. You solemnly swear or affirm that you will make a true and accurate translation between the court and the defendants.
Yes, I do.
Okay. Mr. Manuel Machin, would you state your name, please?
Señor Manuel Macho, ¿puede usted por favor decir su nombre? Manuel Medina Machin.
And how about you, Jose? Can you tell me your name?
¿Y quiere usted, José, puede decir su nombre?
Sí. José Javier Medina Machin.
Yes, José Javier Medina Machin.
These are, you're charged with fishing/gaming violations.
Ustedes son acusados de tener unos incumplimientos.
It-
Pues,
it-
está pescando.
It is alleged that each of you were fishing without a license.
Se alega que cada uno de ustedes estaba pescando sin tener una licencia para hacerlo.
That is a
Yes.
misdemeanor.
Y esto es un delito menor.
It is punishable by up to $100 fines, 90 days jail, costs are all those. Do you understand that, Mr. Manuel Macho?
de $100 o máximo de 90 días en la cárcel como combinación. ¿Está claro con eso, señor Macho? Yes, yes.
Do you understand that, Mr. Jose Medina Macho?
But can we just pay fine?
No,
No.
just bear with me. Do you understand that, Mr. Jose Medina Macho?
Y señor José Medina Macho, ¿usted comprende eso también?
Sí.
Yes.
All right. Where's the advice of rights? I don't have one, or do I? We gotta give these guys advice of
They
rights.
were supposed to, I thought they were giving.
Tell them to give them to them. I can't now. I've got to go through this with,
Hang on.
all right, listen. Each of you are presumed innocent.
Cada uno de ustedes se supone que son ustedes.
Do you understand that, Manuel?
¿Comprende usted eso, Manuel?
Sí.
Yes.
Do you understand that, Jose?
¿Y usted se comprende?
Yes.
Yes.
You have the right to a trial.
Ustedes tienen el derecho de tener un juicio.
You have the right to a jury trial.
Y tienen el derecho de tener un juicio jurado.
At that trial, you have the right to question their witnesses,
Y en ese juicio usted tiene el derecho de interrogar partes.
to bring in your own witnesses,
Tiene el derecho de traer a sus propios testigos.
to use the subpoena powers of the court to bring in those
Es
witnesses.
derecho de usar el poder de citar a otras personas que vengan a necesitar.
You have the right to testify or remain silent at that trial. If you remain silent, that silence would not be held against you.
Guarden silencio durante el proceso de silencio, no le pueden perjudicar.
If you plead guilty, you're going to be giving up all of those rights and we will not have a trial of any kind. Do you understand that, Manuel Macho?
No van a tener un juicio de ningún tipo y renuncian todos estos derechos a mí. ¿Comprende usted eso, señor?
Oh, sí. Entonces, ¿vamos a pagar la multa o?
And so we're going to pay a fine for what?
Just bear with.
Por favor, eso.
I'm not trying to lock you up over having a fishing without a license charge.
Quiero demandarlos a la cárcel de
Okay, so just relax.
Respiren
Take a deep breath.
profundamente.
It'll work out. Okay?
¿Está bien?
So do you understand everything I've said, Manuel Macho?
Así que Manuel Machel, comprendiste todo lo que se ha dicho.
Sí.
Yes.
Do you understand everything I said, Macho and Medina?
Y señor Machel Medina, ¿está comprendido todo? Yes.
Now, Jose Medina Macho, I'm sorry.
Y me refiero a José Machel Medina. Disculpe.
All right.
Yes.
So you have the right to a lawyer.
Usted parece que tiene el derecho de tener un abogado.
I will be happy to provide each of you one at public expense if you would like one.
Y les gustaría tener con mucho gusto que le nombro uno por parte de la corte sin costo a ustedes. Yes.
Do you want a lawyer, Mr. Manuel Macho?
Y señor Manuel Machel, ¿quiere usted tener un abogado mucho? Yes.
Do you want a lawyer, Mr. Jose Medina Macho?
Y señor José Medina Machel, ¿quiere usted también un abogado? Yes.
I am entering a not guilty plea.
Así que voy a procesar la declaración de no culpa
I'm giving each of you a $100 personal bond.
y le voy a dar a cada uno de ustedes una
You
fianza
do not have to post any money.
por esta razón no tienen que pagar dinero.
Here are your bond conditions.
Pero estas son cuáles son las condiciones.
You cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. My court officer is going to bring the files to the prosecutor right now. You will go in there and talk to your lawyer. You will go talk to your lawyer first. And then your lawyer will go in and talk to the prosecutor with Ms. Villarreal.
Ajá.
Do you understand that?
¿Han comprendido eso? Yes.
Okay, I'm entering a not guilty plea, like I said.
Y como les dije, voy a procesar una declaración de no culpable.
Okay, so we'll take those files to the prosecutor. You can have a seat outside.
Así que esos expedientes suyos los vamos a mandar a la fiscalía, se pueden presentar afuera.
All right. Any questions, gentlemen?
Señores. No.
I mean, it's
Lawyer, yeah.
We already have a fishing permit.
good. Tell your lawyer that.
Dígale eso a su abogado.
Thank you.
Alrighty, friends, let's change it up. Let's go down to Texas Judge West. Looks like she's pulling somebody in by Zoom, which we don't normally see. So let's see what that's all about.
Good morning.
Oh, and I will do.
Good morning, Mr. Bell. Can you hear me?
Yeah, I can hear you.
Yeah, good. Okay, so I can hear you too. So I just wanted to, you can see here in the courtroom, Mr. Parker, your attorney's here. And also Ms. Malfino with the state is here. And I have already started this hearing previously in cause number 14-18993. Mr. Bell was found not guilty by reason of insanity quite some time ago for the offense of aggravated assault against a public servant. Has been in the Rust State Hospital, and I have received requests and information that a step down type facility would be in Mr. Bell's best interest at this time. And so, Mr. Bell, I just wanted to talk to you a little bit real quick. I went and looked at the house where you would potentially be going if I allow this. And I really wanted to ask you a little bit about what you have discussed with the social workers there and what your expectations are if you go. Do you know anything about the place where you're going?
Similar to a boarding home, I'm halfway house, like community care home, something like that, but it's a group home.
Right. So it's actually, yeah, and it's very, very nice home. And there would only be, I think, maximum 2, maybe 3 of you there. So it's not a big group home. It's just a regular house in a neighborhood. And so the most important thing to me, Mr. Bell, is that you continue with your medication. Do you understand the importance of that?
Yeah, if I take my medication, I do a whole lot better than trying to go without it.
Right. So if I let you go live at this house, I want to make sure you understand that if you miss your medication, even just one time, there's going to be someone there always, and they'll make sure you take your medicine. And if you don't take your medicine, either refuse to or skip it for any reason, then they'll let me know that, and there'll be an order sent out, a warrant for you, and you'll be right back in jail and probably right back in Rust. You understand that, how important it is?
Understand that.
Okay. Also, obviously there's rules there, just like you've been following at Rusk, and you would be required to follow those. You understand that as well?
Yeah.
And do you have family here?
Am I like in Beaumont?
Yeah, you have a sister around here?
But my second to the oldest sister lives in Beaumont in a brand new house. My little brother stay in an apartment, the baby of the family, John Glenn. He live in Beaumont.
So it would be nice, you would be able to see them, they could come see you. I do want to make sure you understand, though, that you couldn't go stay with them unless you had permission. You have to stay and live in the house, and you have curfews and things like that. You understand? You're okay with that? Okay. All right, is there anything you want to ask Ms. Malfino or Mr. Parker?
I don't believe so, Judge.
All right, so I think, Mr. Bell, what I'm going to do, I've only done this a couple of times, and you probably even know the ones that I have done this with there at Rusk and let out, and they ended up right back there a few years back. And so you probably know who I'm talking about. I don't want that to happen with you. I think it sounds like you're a great candidate for this type of home, and so I'm going to allow it. And so I just want to make sure you and I had this conversation, that you know that you have to follow every single rule exactly like they say, okay?
Okay.
And this will give you a little more freedom to be here locally where you can see family and things like that as well. All right?
All right.
So we'll we'll get the paperwork done. I don't know exactly when all of it will take place, but it'll happen very soon. I am going to find at this time that treatment is still required, but that a lesser restrictive environment is appropriate. And I will set out an order with all of those rules with regard to medication and things like that for you to follow. And as soon as all that's done, they'll work out getting you transferred here. Okay.
Yeah.
You good? Okay. All right. Sounds good. Y'all take care.
Take care too. Good.
Thank you.
Interesting. Judge admits that in the past this really hasn't worked out. Oh, I think my mic was muted. Let's try that again. What I said was interesting because Judge admits that she's done this in the past and it really hasn't worked out. But we're trying again, I guess. So we'll see how it goes. Let's go across the hallway. Judge Stevens.
Right. Placed on 10 years deferred or unadjudicated probation for aggravated assault. A month and a half ago.
All right, just a quick pause. So yeah, you said that it was echoing. So the board was reading different than what was really happening. I think I fixed that now. If I didn't, let me know.
What's this? It says the defendant is not in compliance with curfew requiring him to be inside of his home every day between 8 p.m. and 6 a.m. Are you kidding me? This is your godmother talking. Due to his non-compliance, the probation office is requesting that you be required to serve the remainder of your 180-day jail sanction to begin May 22nd in 3 days. I know there's something wrong here. I think from the old movie, what we have here is a failure to communicate. That, if found true, is enough to revoke your probation and sentence you to 20 years in prison. That's all there is. It's already here. It's obvious that you didn't take any of this seriously. Or you would have acted differently, but do you have a pre-sentence report? If you have a chance, let me just look at that real quickly, please. Thank you.
That's for trial.
That we can still wait for. From the followers, and this is from paper feedback and what from the United States. Well, then,
Okay. Is he doing weekends? Is that what it is?
Yes, sir.
You don't do weekends when you're sentenced to 20 years in prison.
yes, sir. But for now, she saw that.
I see, number 18, be in your home every day between 10 p.m. and 6 o'clock a.m. except for employment. According to probation office, this is not what's happening. When the order was signed by this court on your curfew,
due to the serious nature of this criminal offense, an early curfew is deemed necessary and appropriate. So it was 10 p.m. to 6 a.m. And then what I've done is I've signed an order amending the conditions of probation as of May 11th. So your probation order is 2 hours earlier because you're having a problem following the curfew that was granting you an extra 2 hours. You lost 2 more hours. Plus you're about to go, you got 1 foot in prison for 20 years. May I highlight? Victim, I recall this, was at a barbershop.
Yeah.
Waiting on his brother to get his haircut finished when you stroll in and begin punching him with your face. The assault was on video, by the way. Shows you assaulting the victim without provocation. And you were heard saying, this is the type of shit we do, roll up on niggas at the goddamn barbershop. Are you kidding me? I ought to stick a bar of soap in your mouth, like my mother would do if I used poor language, vulgar language. You think this is intelligent thought? No, it's foolish behavior. This is it. You just stroll around this town and beat up on people. That's what you do for fun. Nothing else in your life. Nothing else in your life. It's gonna be hard to do it when you're in jail or in prison for 20 years. That's vulgar. It has no place in civilized thought, in civilized communities. You're the problem here. You're the problem in this county. People just like you. Can't even go to the barbershop without thuggery. Shame on you. Shame on you. Well, first thing I'm going to do is, you're not going to do this. So you've been on probation just since March, right? Don't understand this. Okay, let me get this straight. This event we're talking about here, that we put him on probation, that occurred on October 30th of last year. And we thought that you would follow the rules. So where are you when you're not at home, when you're supposed to be? What are you doing?
I'm here.
No, you're not. I'm sorry. Well, I got a letter says that your godmother states you're not coming home at 8 p.m. Is she telling me a lie?
She don't know me home.
Is she the liar?
Judge, why you do that to us? Bad, Judge. Bad. Did he realize that he said a controversial word and that's why he deleted it? It's possible. I don't know. I hate when he does that. All right. Well, I was getting into it. Now I don't know what to do because I didn't have anything planned. Let's go. Michigan. Judge Simpson, I guess. Bad judge.
Potential conflict between this honorable court and the office of the public defender. While the people do not believe that any such conflict exists, we make this waiver in the avoidance of all doubt.
All right. Yeah, we don't.
Yeah, he's right here.
Can you do the waiver?
Good morning, Your Honor. I will stumble through it. Lord Yagi, Assistant Public Defender. We likewise do not believe that any such conflict exists, but in the avoidance of all doubt, we would waive any conflict between this honorable court and office.
All right. Thank you. Well done.
Thank you.
The court, for its part, also does not believe there's conflict either in the Michigan court rules or the cases decided thereunder. To the extent conflict does exist, given the waivers, the court will consent to hear the matter. Court does call the case of the people of the state of Michigan versus Nico Caillou.
Good morning, Your Honor.
Good morning, Your Honor. Edward Drukas on behalf of Nico Caillou.
All right. And can you state your name?
My name is Nico Caillou.
Thank you. I have before me a finding.
Not sure what I mean in court here today for, but I'm pleading not guilty.
Yes, sir. There's a finding.
I want to make sure you have the right one. There was also a misdemeanor one.
Excuse me?
I had sent over two that I had received, one for this case.
I have the 123 F5, this one.
Okay.
That indicates that he is at this time incompetent to stand trial.
That's the
finding.
Yes.
All right.
Well, he's before the correct, Judge?
Yes. He's incompetent but restorable. Is there any other additional evidence from either side?
Stipulate to the report, Judge.
Thank you.
And we would also stipulate.
All right. Based upon that report, the court would find that the defendant is at this time incompetent to stand trial. I do need it.
With the competency court.
Hang on, sir. I do need an order, Mr. Drukas.
Okay.
I will set a competency review hearing for.
Your Honor, would you like this in front of yourself or Judge Barr?
Is this a Judge Barr case? In front of Judge Barr.
September 1st.
September 1st, 2026, 9 a.m. before Barr.
Thank you, Judge.
Thank you, Your Honor.
Bond will continue. Thank you. Court does call the case People versus Leslie Ferenczi.
What's your legal?
Morning, Your Honor. Dan Garrett on behalf of Leslie Ferenczi.
Wesley Ferenczi.
Thank you.
Remember, it was resolved this case, payment of $2,000 restitution. First check that needs to be out.
Stop. Counsel approach, please.
Alrighty, we're a couple minutes in the Wayback Machine, so let me see if I can bump this forward past this. If not, we'll There we go.
Approaching.
How did I end up with both? Usually I get one. Never mind. Good morning.
Red line read.
Thank you.
Your Honor, this is daytime set of preliminary examination as well as upon violation if the named people are unable to proceed.
Defense for dismissal.
Before I dismiss it, it's bond violation was a bit troublesome.
Your Honor, I'm sorry. I did receive notification yesterday, but the bond violation was simply, he did not realize he was in that zone. Is the one you're talking about?
That's the one I'm talking about.
Is that the May 18th?
May 16th.
I don't have that one, Your Honor.
Where he was exclusion zone. Graduation party, allegedly.
Oh, okay, I'm sorry. It says 14th through 17th. 16th. Yeah, he did, he was a passenger in the vehicle, and the vehicle was there. Once he was told about it, he explained that it was there.
Once he was told about it, he went deeper into the exclusion.
He was, again, the passenger in the vehicle, not the driver. And he asked to be removed from there as the passenger, and without money on him to pay for a ride, he felt at the mercy of the driver.
Was he admitting to the violation?
Yes, sure.
Defendant admitting to the violation. I'll sentence the defendant. You went into custody, what, yesterday?
Sunday.
I'll sentence the defendant 3 days. Washtenaw County Jail, credit. 3 days served. Case is people being unable to proceed. This case is dismissed on defendant's motion. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Jennifer McCready.
Good morning, Your Honor, reading the cook for the people.
Good morning, Your Honor. Good to see you, Matthew Mansour. On behalf of Ms. McCready, who stands to my right, Jennifer, can you please state your name for Judge Simpson?
Good morning, Jennifer McCready.
Thank you.
Your Honor, some people are unable to proceed.
Your Honor, the defense would respectfully move for a dismissal, please.
People being unable to proceed, this case is dismissed on defendant's motion. Thank you.
Thanks, Your Honor.
Court calls the case, People versus David Barr.
Good morning, Your Honor. Jasleen Singh on behalf of the defendant, Mr. David Barth. Mr. Barth, please state your name for his honor.
David Barth. Whose case is this?
This is Will and Bruce. I can go grab for Your Honor.
Okay.
Jake, can you put the vehicle, Your Honor?
I prefer Willingburn.
Me too, Your Honor.
Thought I'd point that out.
Go ahead.
Your Honor, today is the date and time set for preliminary examination. At this time, people are unable to proceed.
You have a motion to dismiss?
Yes, Your Honor, we do.
People being unable to proceed, this case is dismissed on defendant's motion. That's without prejudice.
Thank you.
Thank you. Court calls the case of the People's State of Michigan versus Gabriel Hamby.
Good morning, Your Honor. Randy House.
Called Hamby.
Yes, ma'am.
Sorry, I was in the hall, Judge.
Sorry.
Kimberly Stott on behalf of Mr. Hamby, who's standing to my right. Would you state your name for the record?
Gabriel Hamby. Thank you.
I have here a waiver form. I can hand it to your deputy.
For the record, I'm full.
Examination.
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People are having waived their right. Preliminary examination is waived. Defendants bound over to circuit court on counts 1 through 4 with 5 following.
Thank you, Judge.
Gonna hang on. As to the arraignment, circuit court arraignment, we do that here.
Oh, I'm sorry. I'm not real familiar with this court.
Knowledge.
That's great.
Knowledge receipt of the information.
I do.
Waive its formal reading.
We do.
Client stands mute at this time.
That's correct, Your Honor.
And then having waived formal reading, standing mute, court will enter a not guilty plea as to all 5 counts. Pretrial in this matter will be set for
July 16th at 1:30 with Judge Slay.
July 16th, 2026, 1:30 for Judge Slay.
Thank you very much.
Bond will continue. And yes. You know. I should just, yeah, why hey.
Please.
All right, as bonds continue with Judge Simpson, let's go back down to Texas and Judge West, new contestant there.
Mr. Stansberry, this is 26 DCCR 0174. You're charged with the first-degree felony offensive murder. Mr. Burbank, what is the announcement?
Filed a rejection. Various charge, the offer was 40 years.
All right, let me go through that. So, Mr. Stansberry, what you're formally charged with is obviously the first-degree felony offensive murder. And that is from November 7th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum of 5 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a document that you've signed entitled Plea Bargain Rejection with Mr. Burbank. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 40-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. You understand all of that? And you want to reject that offer and have your case set for trial. All right, we'll get that done. Mr. Smith, is there any reason to believe that that offer would change?
I don't think so, Judge. This is actually Luke's case. I was just covering for him this morning, but by all accounts, there will be no reductions here.
Nothing, as far as you know, not waiting on any type of discovery or
I
evidence?
think there's
Got it all.
nothing that's standing out that
Okay.
is going to delay.
All right, so I want to make sure you understand also, Mr. Stansberry, that after today, I will not accept this agreement. The only reason I would accept this or something different or better would be because some different evidence or information came to light that your attorney and the state's attorney didn't know at this point. You understand? All right, we'll get it set on the trial docket. Mr. Burbank will be in preparation for trial.
I think that's it.
Yes, sir. Thank you.
Thanks so much.
Mr. Lewis, you have Brandon Bonton.
Yes, ma'am.
Brandon. Exactly that is 1, 2, 3, 4, 6 cases. Good morning. Oh, did I miss a whole page? I did. There we go. 1, 2, 3, 4, 5, 6, 7, 8, 10 cases. Good morning. Are you Brandon Bonton?
Yes, ma'am.
And this is cause numbers 26 DCCR 0277, 278, 279, 280, 281, 282, 283, 284, 184, and 0490. And Mr. Bonton was examined for competency to stand trial by Dr. Grimsley. I've received that report. I'm going to take judicial notice of the court's file in all of the cases. The report is dated April 14th of 2026. The finding in that report is that Mr. Bonton is currently not competent to stand trial, and that inpatient treatment for competency restoration would be warranted. Is there any other evidence with regard to competency?
No.
No, at this time, then I am going to find that Mr. Bonton is not competent to
Can I
stand trial. Hang on, let me say what I need to first, and then I'll let you.
Illuminati, man. I got the government microphone chip in my left knee, my right ain't hollow. I've been to the hospital. I understand the courts, man. George Bush know me. I'm not lying about nothing. I testify and take a lot of ticket tests. I'm innocent. I got the right to freedom of speech, man. I'm asking for probation, 2-year cap. If I go home today, because these people on the Illuminati application on their phone is manipulating the government system through my chip. I do hear voices. I don't take medication, and they force you to take medication and join S. Dunn Behavior Center. Coach Lewis know me. I was sitting here. I had an aggravated robbery job. I shot a 9mm 2 times, one third way.
Mr. Bonton,
German Daly shot that 45.
Go back with the bailiff. You can go with the bailiff.
Talk, man. I'm sorry about that.
All right, I'm going to find that Mr. Bonton is not competent to stand trial. Make
Sacrifice him, man.
That inpatient restoration treatment is warranted. Order that he be sent to the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility. The lot. All right, let's see. Mr. Eckhart, you've got Mark Marceau.
Judge.
3 cases. Good morning.
Morning, Judge.
I think that needs to become a full case.
Hey, can I go on my stuff, man? If they rather be murderers than rapists, go like, don't keep their pace, bro. But a brother, the fucking nigga call me.
Good morning. Are you Mark Marceau? Are you Mark Marceau? This is cause numbers 26 DCCR 0396, 397, and 398. Mr. Marceau's charged in 2 of the cases with sexual assault of a child, and the third with continuous sexual abuse of a child. And what is the announcement?
Judge, Ms. French and I spoke last week about this case and about our plan. She's still in the process of obtaining CPS records. At some point in the near future, we're going to file a request with the court for a bond reduction. And those are the 2 kind of most urgent matters that we've got.
Okay. I don't see that request has been made yet for the CPS records.
And not yet. I've been preparing for trial that didn't occur yesterday.
Right.
I'll be preparing that motion in order, Your Honor, and also whenever the hearing is for the bond, if I can have a little bit of notice because of the family dynamics here, obviously the state will argue against that.
So what I'll do right now is just do a 60-day reset. Obviously, if you file a motion for bond reduction, we'll move that up immediately to a court date for that. And then we'll kind of push it back a little bit. The CPS records take some time to get. And then, so if you can get that, Ms. French, I'll get that signed this week. And that way we can get that process started. And then we'll see where we are, but we'll move it up for a bond reduction hearing.
Thank you, Judge.
All right, thank you. You can go back with the bailiff.
If you want to look at the video this week, it's a
Let's see, Mr. Brian Lane.
Yes, ma'am.
You've got Khalil Bradley Harris.
Yes, ma'am. That'll be a please.
I'll hold it till the paperwork's ready. And then what about Heyman Brandon?
If we may approach on him just for a second.
The court allowed me some time.
Let's get Mr. Brandon out here. So he's Heyman Brandon.
Heyman Brandon.
Yeah, just hold on a second since he's here.
Okay.
Let him know what's going on. All right, you're Heyman Brennan. And this is 21-36605. Mr. Brandon is charged with murder, and what is the announcement?
Your Honor, we're respectfully requesting one more announcement. The court has reset it today for us to get an insanity evaluation from Dr. Rapon. It took me a little while to get to Dr. Rapon. I spoke with him yesterday. He said if I'll get him the materials, he could have an evaluation report done within 2 weeks. So if we could just have one more 30 days, I believe that's going to.
My concern is deterioration in our jail because we finally have competency after years of not.
Right.
And so I need that done. This is, I'm going to reset it 3 weeks. We need to have it done within 3 weeks. And so.
I may be on vacation until the 15th, so.
Do you have a vacation letter in? Okay, well, we'll take that into consideration.
Okay, also, if, respectfully, if we get the report, I think the state's gonna look at it. If the state wants to move forward, then we're going to ask for a bench trial. You want to set that in?
Well, let's see what the report says so that we know which direction we're headed once we get that report.
Oh.
So we'll just set it for an announcement, and then that day we'll know for sure what we're doing one way or the other. Okay, sounds good. You can go back with the bailiff. Mr. Lewis? Mr. Parker, you've got Donald Cogdale's of sentencing.
Parker.
Donald Cogdale.
Cogdale. We go back for a minute.
While we wait for the next contestant and have some dead air, reminder tonight, sidebar, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel.
You are Donald Cogdale,
Yes, ma'am.
and this is 26 DCCR 0005. Mr. Cogdale was previously in court, entered a plea of guilty to evading arrest or detention with previous convictions, and also pled true to prior convictions, making this offense a second-degree felony. The agreement was for a cap of 8 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor, and I want to commend Justin Riley on what a great report he wrote. He really did it.
Ms. Malfino,
I have to.
any additions or corrections?
None, Your Honor.
Judge, obviously, I am aware that the criminal history is of concern to the court. As you know from the indictment, the underlying offense itself is a state jail felony. and the offer was made, just predicated on the nature of that offense with these priors. I'll defer to whatever you think is appropriate, if in fact you think 8 is enough. No, I'm intended.
So I want to make sure, what's the status with parole? You're on parole, correct?
Yes.
Have you had a hearing out at the jail? Have they come to the jail for a hearing? Have you talked to anyone with parole about this case?
Somebody called over there. I don't know who it was.
Okay.
There's something about parole, not parole, but like, I don't know, I don't understand what he was saying.
Okay, there's a hold on him, correct? Sure. Mr. Parker, you may proceed.
I've had this same issue trying to figure some of this stuff out, Judge. I've talked to him, and the facts of this case, I mean, to my understanding, what the probation calls it, he was living in a transitional house. And I've talked to him about where he's going to live. He intends to go back to the transitional house, and he was working there in the kitchen. And the facts are that he was out. It started pouring down rain. He went to a house. He was on the back porch that he thought was vacant, and he was on the porch getting out of the rain. And 5 cop cars pulled up. And as he says in his report, I asked him, "Why did you run?" And he said, "Well, 5 cars pulled up and I got scared." And I mean, I've heard that a lot, but I mean, I think he's sincere in that. Not that it's justifiable, but that's what happened. He wasn't trying to break in the house, and that's what happened in this case. And I would point to the probation officer that thinks he might respond better to a structured guidance than to extended incarceration. It's in the top paragraph on page 5, the last sentence. And that's kind of my position. I think the last time he was in trouble, well, he's obviously been incarcerated, but was in 2017. I clearly think that the probation office has pointed out everything that's about him thoroughly in this report, and just going back to his childhood, how he's raised and how he's lived, and his educational standing and his mental capacity. I think he's competent, but it's not as high as a lot of people that are out there, and he struggles to get by. But if it's possible, I think we would request he be allowed to be placed on probation. Understand the question about parole. Otherwise, we ask for a low read.
Small Fino.
Judge, I really don't have much additional. I don't think he's a suitable probation candidate, although inference can be made from the offense itself that could have very easily turned into a burglary. I'm just glad we're not here on an offense involving him actually being inside someone's home or involving a child. So, but based on the mitigating factors pointed out by Mr. Riley, I'd ask the court to consider the 8.
So, Mr. Cogdill, I appreciate your attorney's argument. I understand. I can see that there's some issues cognitively. However, there's no doubt that you understand what's going on, right?
Yes.
Yeah. So you've been sent to prison 6 times, and you're currently on parole for 3 burglary of a habitations, delivery of a controlled substance, evading arrest or detention with a vehicle, and then a indecency with a child. And it makes no sense to me that you were on parole and had opportunities through parole to get any help that you needed, and you didn't take advantage of that and were out doing whatever you were that you shouldn't have been doing, and then ran. So at this time, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with previous convictions. Find those prior convictions true that you pled true to. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, you can go back with the bailiff.
Alrighty, friends, now in hour 3 of TCF Live on this fine Tuesday morning. It's good to have you all here. Let's go back up to Michigan. We'll check back in with Judge McNally.
Good morning, Your Honor. Michael A. Carmen, P73824 on behalf of the defendant.
So I understand that this will be a waiver. The prosecutor's written no objection to waiver. Is that true?
Yes, sir.
So, sir, you're charged with possession of less than 25 grams of cocaine. That is a 4-year felony. You have the right to a preliminary exam. At that preliminary exam, the people have to show that the crime was committed and that you were the one who probably committed the crime. If you waive your right to an exam, you're waiving that requirement, and you will automatically be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that?
Yes, sir.
Anybody force you to give up your right to a preliminary exam?
No, sir.
And you still wish to do that?
Yes, sir.
All right, I'm going to accept the waiver. I find the waiver has been made voluntarily and understandingly. You're bound over for further proceedings to the Wayne County Circuit Court. June 2nd at 9 a.m. will be the AOI date, the arraignment on the information. Bond is 10,000 PR. Prosecutor did not indicate they have an objection to continuation of the bonds, so the bonds continued. You've been going A, correct?
Yes, sir.
Let me see it.
Yes, sir.
Let me see it.
Oh, I didn't know I had that option, sorry. So,
Where is it? Where is it?
It's that one.
Well, you only live in Rockwood. You can go get it then, right?
Yes. And,
You have it all done? You've been going twice a week?
yeah, yes, I have. I actually, I went a step further, Your Honor. I committed myself to, with the Oakdale, recovery.
Have you been testing weekly here?
Yeah, come back negative.
You're to continue testing weekly, okay? You're to continue going to AANA. You're gonna have to bring it down. If a circuit judge sees you without that, they're likely to revoke your bond. You understand what I'm saying?
You want me to come back right now?
No, I'm gonna take it at your word, but
Thank you,
you
sir.
make sure you're going.
Yes, sir.
So your next court date, as I said, will be on June the 2nd. You could go down the hall and get your notice. Mr. Carmen, anything else on it?
Nothing, Your Honor. Thank you very much.
Have a good day. Good luck, sir.
You too.
Thank you. Kobe Rashard Ferguson, 25B725-812, 25B728899. All right, Ms. Oro, your appearance.
Yes, good morning, Your Honor. Madison Oro on behalf of the people, PA8398. I realize my camera's not on.
Okay, Mr. Nasser.
Yes, good morning, Your Honor, and to your staff. May this most honorable court, Mohammed Nasser, P74485, appearing on behalf of Kobe Ferguson, who appears via Zoom, consents to their hearing over Zoom. Mr. Ferguson, identify yourself for the record.
He's coming in right now, Judge. It was moving a little slow.
Did we ever get the competency report back?
Judge,
We
got
did,
the-
Judge.
Yeah, we got the Forensic Center's competency report back.
Yes, Kobe Ferguson.
Okay, sir, I'm gonna need to hear you, and you're gonna need to keep your voice up nice and loud, okay?
Yes, Kobe Ferguson.
Can you turn another light on there, please?
Yes. Is this better?
Yeah, that's 100% better. Thank you very much.
No problem.
Give me 1 second. I don't believe this was my case initially. Did Judge Hessen make a determination that the defendant was competent to stand trial yet?
Not, Judge, may it please the court?
Yeah.
Thank you
Go
so
ahead.
much, Judge. The evaluation came back from the Wayne County Center for Forensics. I found him competent. We were seeking an independent, but at this point, we are prepared to set this for an exam, and we'll deal with any other criminal responsibility issues at the higher court.
Okay, so, but there was never a finding by Judge Hessen that the defendant was determined to be competent to stand trial, true?
That is correct.
All right, so we're going to conduct that right now. Did the parties stipulate to the admission of the report that looks like February the 27th of 26?
We would stipulate the same, Judge.
All right, I'm going to have that marked Peoples 1. Does anybody have any evidence? I'm just asking as a matter of routine here. Ms. Oro, I presume not?
I do not, Judge. Thank you.
Don't either, Mr. Nasser?
No, Judge.
So I'm going to the parties stipulate to the admission of Peoples 1, which is the forensic report dated February, is that the 27th?
No. Yes.
All right. And nobody else has anything else to say, correct?
Correct, Judge.
Correct, Ms. Oro?
Correct, Judge.
Based on my review of the report, I'm going to find that the defendant is in fact competent to stand trial. That's based on the report of Laya Marshall, PhD, a licensed psychologist and consulting forensic examiner. And that report was received by the court on February the 27th. So I'll find the defendant competent to stand trial. And you're withdrawing any request for an independent forensic, correct?
At this point, yes.
All right, so we're going to set this for exam. And that will be, when can we do this? I don't need it to be a Tuesday. Can't be a Wednesday. I'd like to.
I would ask this court for some available dates, and I have my calendar, Judge.
Well, you tell me. You guys pick a date. I'm so easy to get along with. You pick a date. It just can't be Wednesday afternoon, or that's probably it.
Thank you so much.
How about next week, Monday or Wednesday? Is that enough time?
I don't know about Mr. Nasser.
Monday's
Judge.
a holiday, Judge.
That's
You can't
well,
you can't
well,
do
I figured
Wednesday.
these lawyers were so hardworking they'd come in on Memorial Day. I'm just kidding. All right, what about the week after? What about the week after that on a Monday? Do I have any availability on the 1st of June, Lisa?
Yeah, in the afternoon you do, 1 o'clock.
Can you guys do June 1 in the afternoon?
Judge, I cannot do June 1 in the afternoon. I have many hearings, and I'm just not I have no faith that I will get to you on time. I could do that the second on the Thursday, and I could do the following week as well, starting Monday, June 6th.
It's Monday, June 8th.
Oh, am I
Right.
looking at the wrong? I think it would be Monday, June 6th,
June 6th is a Saturday.
Okay, my calendar is wrong in front of me. So whatever that
Wait a minute, I can't hear you at all, Mr. Nasser. Hang on, slow down. Can you guys do it on Monday, June the 8th at 1 p.m.? Am I good then, Lisa?
You have a jury trial at 10 o'clock that day.
What's the name of the case?
Michael Rebant with Mr. Ramsayer.
I don't want to go past that.
Judge, could we do June the 12th, Friday? I'm available
No,
that
I'm
entire.
not here. I'm not here. I need you guys to figure out a date, go into the breakout room with you, if you would, please. I can't. I've got a little bit of. So you can't do it the 1st. I got a jury trial on the 8th. How about the 9th?
Judge, I can do the 9th.
In the afternoon? Am I good, Lisa?
Let me check. Yes,
Where's
you're
that?
good that day.
Mr. Nasser, you good for the 9th?
We'll make it work, Judge. The afternoon meeting, 1 o'clock.
Yep, June 9th at 1 PM, okay?
Perfect. Thank you.
We'll be there.
Anything else anybody needs to bring up?
Nothing from the people, Judge. Thank you.
Nothing
All
from
right.
defense.
Wait a minute, let me just do this. Give me 1 second here. We do understand, and I called both cases. I just want to make clear for the record that the report that I marked that we received February 27 also pertains to file 25B728899. So there's a second charge, different incident date, defendant found competent to stand trial on that file as well. People's 1 admitted pursuant to stipulation. And we'll set it for exam. I'm going to do one after the other. So I hope we're going to have all these witnesses here. So we're going to do the same date, June the 9th at 1 PM on this one.
Okay, sounds good, Judge. I was actually just going to ask if that
There's
included
different
both.
witnesses. I didn't get far enough to check, but they'll just all have to be here at 1 if they would, please. Okay?
Okay, Judge. Thank you so much.
Thank you very much. Have a good day, ladies.
All right, now that they got all of that sorted out, let's go back to Lake County, Ohio. Judge O'Donnell, aka Judge F Word.
Court, there is no agreement at this time as to sentencing.
Mr. Matthews.
That is accurate, Your Honor.
Ms. McAdams, how old are you?
I just turned 35 today.
How far did you go through school?
The 10th grade.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, sir.
You ever been diagnosed with or treated for any mental illness?
Yes.
What have you been diagnosed with?
With PTSD, bipolar depression, and mood swings.
Are you being treated for that right now?
Yes.
Where?
At the centers on Euclid.
All right. Are you taking any medication for that?
Yeah, but I'm not allowed to take it here.
You understand what's going on here?
Yes, sir.
And you're going to plead guilty to theft to felony 5, is that correct?
Yes, sir.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Matthews some more, let me know, and I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
If you are waiving that right, the answer to the question would be yes.
Oh, yes.
If you go to a jury trial, all 12 members of that jury must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes. Yes.
Are you waiving that right?
Yes.
If you could not afford a copy, the transcripts would be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of your rights?
No, sir.
Do you still want to plead guilty to this charge?
Yes.
You understand by pleading guilty, you're fully admitting your guilt to the charge.
Yes.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes.
Theft is a felony of the 5th degree. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes.
Are you presently on post-release control to the parole authority?
No.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 6 months. Do you understand that?
Yes.
If the violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
And if that were to happen, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. Do you understand that?
Yes.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk with Mr. Matthews before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions?
No.
Ms. Contour, if the case went to trial, what would the evidence show?
Thank you, Your Honor. The evidence would have shown that on February 17th of 2026, the defendant entered the Alta in Manor Lake County, Ohio. She went to the perfume section and took a significant amount of the tested perfumes that were out. That totaled $4,472 and left the store with all of those items.
All right, Mr. Matthews, anything to add to those facts?
No, Your Honor.
Ms. McAdams, did you hear what Ms. Contour said the facts would show if the case went to trial?
Yes.
Are those facts true?
Yes.
What is your plea to theft, a felony of the 5th degree?
Guilty.
Mr. Matthews?
Thank you, Your Honor. Prior to the hearing, I did review the written plea of guilty with Ms. McAdams. She indicated that she understood it and that she intended to sign it. It's 519, and then your signature on that one.
Your Honor, I did witness the defendant as well as Mr. Matthews sign the plea of guilty, and I signed it as well.
Ms. McAdams, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
All right, I'll accept the written plea of guilty. Defendant was present. Mr. Matthews advised of all of her rights with a knowing, intelligent, voluntary waiver. She understands the nature of the charge, the consequence of her guilty plea, and the maximum penalty. Finds the knowing, intelligent, voluntary will accept the plea of guilty and find her guilty of theft, of felony 5. I'll refer this for a pre-sentence report, and the victim impact statement. Sentencing will be June 24, 10:15 a.m. The bond is revoked. Anything else, Ms. Contour?
Nothing, Your Honor.
Mr. Matthews?
No, Your Honor. Thank you.
All right, we're adjourned.
All right.
Alrighty, friends, that brings that hearing to a conclusion. Let's bounce back over to Texas and back to Judge West.
Jonathan Richard, that's yours, Ms. Malfino, from what I show.
That's weird. Mine shows paint French.
Oh, Oh, well, I don't know whose it is.
That's weird. How are you? What's Preston's? There you go.
All right, so are you Jonathan Richard? This is cause number 25 DCCR 0248. Mr. Richard was charged previously with evading arrest or detention with previous convictions and was found not competent to stand trial and sent to the John Dunn Behavioral Science Center for competency restoration. Received the report from them dated May 4th of 2026. I'm going to take judicial notice of the court's file. The report states that Mr. Richard has not achieved competency, is not competent to stand trial at this time. There is a trial competency evaluation report, which was prepared by Dr. Turner. And that report is that he is not competent and that current competency restoration treatment would be necessary for competency restoration. In addition to that, there is a forensic psychiatry report from a Dr. Shahani, again, with the finding that he is not competent to stand trial at the present time. Also, there is a physician's certificate of medical examination for mental illness prepared by Dr. Shahani. It makes the finding that the patient is mentally ill, and as a result of that, they state that he does not meet the criteria for inpatient, but meets the criteria for outpatient treatment because the nature of the mental illness is severe and persistent. As a result of it, if not treated, would deteriorate. In addition to that, there is a second physician certificate of medical examination for mental illness from Dr. Select. That has the same finding that Mr. Richard is still not competent to stand trial and that outpatient treatment would be warranted for competency restoration. Any other evidence with regard to competency?
None from the defense judge.
So obviously, we all know, and for the record, we do not have an outpatient competency restoration program here in Jefferson County, nor in jail competency restoration. And so I don't have any choice but to order inpatient treatment because we don't have that, unfortunately, here. So at this time, I am going to find, based on those reports, that Mr. Richard is still not competent to stand trial, that inpatient competency restoration placement is necessary because that is what we have in order. Mr. Richard, for a period of not to exceed 1 year to the appropriate facility for competency restoration. We obviously need to make sure, Ms. Malfino and Mr. Parker, that y'all take a look at the dates on this and how long he has already been in custody. Since it's a state jail felony, we're probably
Should expire while he's in.
So we need to check those dates. If you'll get that date, if you'll make a note so that we know we can get him back whenever that date hits.
Okay, I'll leave it.
All right. All right. You can go back with the bailiff.
Thank you, Judge.
Mr. Rojas, you've got Manuel Cardenas.
No, it was 12.
Okay. We're gonna reset Sarah Jordan.
Jordan?
Mm-hmm.
And also, Judge, we're gonna ask to reset Mr. Pugh. Willie Pugh.
Okay. What's up with that one?
Ashley was going to look
I
at.
just haven't
officer.
able
We
to
haven't
reach
getting
the
all this.
officer yet, Judge, sorry, just 1 week would be.
Yeah,
fine.
we can be fine.
Just to ratify off of.
Good morning, sir. Are you Manuel Cardenas Jr.?
Yes.
This is 26 DCCR 0040. And Mr. Cardenas is charged with injury to a child, elderly, or disabled individual. And once you take, okay, let me take judicial notice of the court's file. Mr. Cardenas was evaluated for competency to stand trial. And Dr. Grimsley prepared a report and evaluated him. I've received that report. It's dated April 8th of 2026 with the finding that Mr. Cardenas is competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor.
Mayor.
All right, and will he waive the formal reading of the indictment?
He will, Your Honor.
Mr. Cardenas, in cause number 26 DCCR 0040, you're charged with the third-degree felony offense of injury to an elderly individual from October 13th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation, which would also include having no contact or communication with Manuel Cardenas Sr. Do you understand?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Cardenas is not competent?
No, Your Honor.
All right, Mr. Cardenas, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case so that we can make sure everything is covered that needs to be while you're on probation, and then we'll come back later for sentencing. And it looks like the state's already, you're opposed to a bond.
I am, Judge, just due to the nature of the case and the underlying need for that competency evaluation. I have not had an opportunity or have not heard back from Mr. Cardenas Sr. And I would just prefer with that PSI to make sure if there's any APS orders, et cetera, in place, that we have a pretty strict no contact structure. Obviously, that's his father.
Sure.
So it's.
All right, we'll see you back at sentencing. You can go back with the bailiff. Kelvin Johnson, Mr. Rojas, it's a sentencing.
Kelvin Johnson.
No.
While we wait for Mr. Johnson to approach, a shout out and a thank you to Grandma TCF. I got up for a second to investigate because I smelled something. Grandma TCF baked fresh blueberry muffins, which I'm sure she did because she knows they're my favorite. So hopefully I get 1 or 10. But in any case, thank you, Grandma TCF.
Good morning. Are you Kelvin Johnson?
Yes, ma'am.
And this is 25 DCCR 1781. Mr. Johnson was previously in court, entered a plea of guilty to the state jail felony offense of theft of property with previous convictions. Entered pleas of true to prior convictions, making this a third-degree felony enhanced. The agreement was for a cap of 5 years in prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Any additions or corrections?
Not from the defense.
Not from state.
All right, Mr. Rojas, you may proceed.
Thank you, Judge. Obviously, Judge, when you look at this PSI, what stands out is criminal history. It looks rather lengthy on paper. I'll point out to the court that most of the misdemeanors anyway are trespassing cases. And I would guess, and Mr. Johnson tells me this is a case that most of those, because he was homeless, didn't have any place to go. And as the court knows, if you're homeless and don't have any place to live, you're going to probably pick up some trespassing cases. He does have two prior cases which, where he got probation and was revoked. I understand that's not a good track record when we're here asking for probation. I will point out, that, I think the most, or the felony probation case was in 2000. And the one where he was revoked on the misdemeanor was in 2020. So a little bit of time has passed, between those two. As far as this current case is concerned, if you look at his statements, he looks like he was stealing food and clothes, necessities. $72 worth, which would ordinarily be a misdemeanor, but with the fact that he already has the two prior theft cases, and the other felony case was bumped up to a third degree. He's asking for probation, Judge. And again, the felony history anyway is from the last felony case is from 2003, it looks like 23 years ago. He tells me that prior to being arrested, he was working for a church, getting paid on a daily basis. I also did some work for a car dealership out in Silsbee. He tells me he can go back to both of those jobs. The car dealer, he doesn't have transportation, but the car dealership came and picked him up and brought him back and forth to work. So that shouldn't be a problem as long as that job is still there. According to PSI, he's going to be living with his mom. So we're asking the court to consider probation, a deferred probation term. If the court is not inclined to do probation, I would ask for the minimum term on this 2 years, given the fact that things he was stealing necessities and the length of time since his prior felony convictions.
Thank you, Mr. Rojas. Ms. Malfino?
Judge, I don't think he's necessarily not a candidate for probation. I think it should include safety. In my opinion, the PSI reads as if he expressed interest in that. I would like to ask him if he really wants to take advantage of that. Otherwise, we're just going to be back here in a year on the same situation.
And I apologize, Mr. Johnson did want to speak to you, so whenever.
All right, go ahead, sir.
So the first charge I ever got, it was in 99. I did my time. I got out. I had a family. I lost it because me and my wife got into it when she took me kids to Louisiana. I not gave up, but I became homeless. I got all them trespasses. Then I started stealing food and clothes out the store. But being in the county for the months I've been in there, I see it was wrong. You know, one thing about me, I live and learn. But two things happened as I was doing what I was doing. I stole out the store and the police came up to me, which they didn't bring me to jail. He told me this one thing. He said, you didn't have to do this. They would have gave you the food. And then showed me instead of stealing, I could just ask. And then another time I was panhandling on College Street at the burrito place. And across the street was a car wash. And instead of me, and I looked and I thought about something. And I crossed the street and I started asking them to wash their cars. So what I'm getting at that is it's better to work than to be doing all that. You know, it's a different way that I'm gonna go by doing things this time, you know.
How old are you?
45.
Yeah, time to start doing things
Yes,
different, huh?
ma'am. Yes, ma'am.
Anything else?
No, Judge.
So here's the thing, Mr. Johnson. If I give you an opportunity today, it's probably going to be, the worst I could do today is give you 5 years in prison if I sent you to prison.
Wow.
You'd be out in 2 or 3 years and that'd be it. If you really want to change your life and you want probation, it's going to be for a longer period of time. And if you violate, the sentence could be for a longer period of time.
Yes, ma'am.
It's going to require safety so that you can have the tools to be successful, to not turn to alcohol and drugs and things like that. So I'm going to kind of leave it to you. If you really want that opportunity, I want you to take it. I'll give it to you today based on, you've been very upfront. Your history is all clearly because of homelessness and drugs. I mean, that's clear. So if you want to change, I'll give you that opportunity. Is that what you want?
For probation?
Mm-hmm.
Yes, ma'am.
Okay. So here's what I'm going to do, Mr. Johnson. I'm going to find that you entered your plea of guilty freely and voluntarily previously. Find sufficient evidence to find you guilty. And at this time, find you guilty of theft of property with previous convictions. Find those prior convictions that you pled true to, true. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. You'll be placed on probation for 10 years. You'll be ordered to follow all of the rules and conditions of probation.
Yes, ma'am.
That is going to include entering and successfully completing the SafeP program. So you'll go to the inpatient part of SafeP in custody, and then you'll get out, you'll have aftercare. All of that's going to help you find a place to live, get hopefully a job, stay clean, do everything you're supposed to. If you do everything you're supposed to, then for all practical purposes, your case here in court's over. You'll be able to serve that 10-year sentence while you're out on probation. But the other side of it is if you violate your probation, I'm going to see all this history. I'm going to wonder why I gave you this opportunity, and you're going to end up with that 10 years that I just gave you. You understand?
Yes, ma'am.
All right, so I'm going to hand you the trial court certification that shows this was an agreement that I followed. So you have waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, sir.
Thank you.
Thank you. No fine.
Okie dokie, friends. We're in our final 20 minutes or so of TCF Live for today. Let's change it up, head slightly east, go to Louisiana, check in on the board.
Poindexter?
Yes, ma'am. I am.
All right, the time is now 10:23, and this is Terrebonne Parish Correctional Center, where you're located. The board members are myself, Ms. Stapleton, and then on Zoom, we'll be joined by Mr. Freeman and Mr. Prater.
Yes, ma'am.
For the record, Mr. Poindexter, will you please say your name and give your DOC number?
I am Gregory Poindexter, 422604.
Okay. All right. Is there anyone in the room with you that wants to speak?
Ma'am.
Okay. All right. Thank you. All right. Do you remember signing a questionnaire? And do you
Yes,
have it?
ma'am.
Okay. All right. Well, based upon the questionnaire that you signed and the answers you gave, not eligible for appointed attorney. Okay? You understand that?
Ma'am.
Based upon the questionnaire, you are not eligible for an appointed attorney.
All right. Yes,
Okay. So proceed.
yes, ma'am.
Okay. All right, let's see. So at this time, sir, I'm going to read your violations, reasons that you were revoked, okay? Number 4, I will not engage in any criminal activity, nor will I associate with people who are known to be involved in criminal activity. I will avoid bars and casinos. I will refrain from the illegal use of drugs or alcohol. You engaged in criminal conduct on or about 1/8/2024 when you were arrested by the Houma Police Department for committing the offense of illegal discharge of a firearm or felony. Additionally, you are being charged with an additional felony of possession of a firearm by a convicted felon, as per bill information filed on 7/18/2024 by the 32nd Judicial Court of Terrebonne Parish. You further engaged in criminal activity, criminal conduct on or about 5/25/2022 when you committed the offense of telephone harassment, which was a misdemeanor, and were arrested by the Terrebonne Parish Sheriff's Office. Okay, at this time, sir, how do you plead guilty, not guilty, or guilty with a statement?
Oh, not guilty.
Okay, did you want to make a statement about it, sir, as to why you say you're not guilty?
Yes, ma'am.
Okay, what is your statement?
Ma'am, I'm gonna be honest with you. I don't know how these allegations came on, but I just want to say the Department of Correction Center, parole board can find it in their heart and in their power to reinstate my parole, because I do not know nothing about these allegations that came upon me.
Okay. Well, I've got your arrest warrant on, and so it says that there were 10 to 12 gunshots in the direction of the Thirsty 30 sports bar. And that the owner, she identified you and she knew you as Bloodline Poindexter. And that you fired numerous shots from a pistol in front of her establishment. And shortly after firing the shots in the air, Bloodline departed in the area in an unknown vehicle. All right. So she called your Facebook and you answered when she called you. She asked, and they had their body camera on, okay? And so she asked, he shot the gun outside her bar. The entire conversation was captured by the department and issued with the body cam. After receiving the information, I returned to speak to the female. This is the officer talk. And so later they found 12 shell casings, which were photographed and then they were collected. And then goes on to say, I feel confident Bloodline Poindexter is Gregory Poindexter. That was the evidence, some of paraphrasing for the arrest warrant for the gun. Any thoughts?
Like I said, I don't know who came up with all the accusations on me. Cause I've been here 2 years. And when I went to court, it dropped it all the way down.
What did they drop it down to?
Disturbing the peace.
Disturbing the peace?
Yes, ma'am.
All right, so they found you guilty, but they gave you a plea bargain then, is that correct?
Yes, ma'am, 30 days.
Huh?
30 days.
Okay. All right. Okay, what about the other one, which was the phone, harassing phone calls? May 17th, 2022, the deputy was dispatched to a certain address in reference to harassing phone calls. And the lady said that you advised you were going to jail, and it'd be because he killed her and her daughter. You got any thoughts about that one?
He killed her.
Yeah, that was if she reported it and did anything about it, that you would kill her and her daughter. You need
No, ma'am, no.
Well, the person that did the claim for harassing phone calls, is this a person that you have a relationship with still?
Yeah, baby mother.
Your baby's mother?
Yes, ma'am.
Yeah, and so, did she tell you to leave her alone?
Plenty of time.
So maybe you did call her during that time?
Yes, ma'am.
Might have called her.
But they ain't saying nothing like that, though.
Okay. All right. And she was advised by the police to change her phone number. Have you been in contact with her since then?
No, ma'am. Before I came to jail, we was in contact.
But before you were in jail, you were in contact?
Yes, ma'am. That's who I was with the day I got arrested.
That's who you were with?
Yes, ma'am.
Okay. It says here, due to the severity of the phone calls and this lady's testimony, they were unable to make contact with you that day. I will be issuing a warrant for your arrest for telephone harassing threats. So that's what was on the warrant. Do my colleagues have any questions from the panel?
I do.
Okay.
Mr. Poindexter, Max, this. So why would they say you had a gun outside that bar? Were you at the bar?
No, sir. No, sir.
So why do you think she would say that?
I don't know, sir.
Did you ever go by the name of Bloodline?
That was my Facebook name.
Yeah, that's
but,
what I thought. Okay.
But I didn't have no gun, and I know I was on how much parole I'm on, and no way I would have been out there like that. Since I've been in, I lost my job. My daddy had five or six heart attacks, had open heart surgery, and I missed 2 of my baby birthdays. And like I just told her, see, the Department of Corrections, parole board could find it in their heart and in their power to reinstate my parole, I would love it. But for the person who put these false accusations on me, I forgive them.
Okay, and you was in jail. You've been in jail almost 2 years.
I've been in jail
and
2 years.
All the charges are gone except the telephone harassment, right? You hadn't been to court on it.
No, all of them
Which
gone.
happened in 2022, by the way.
Yeah, all of them gone.
Okay.
They gave me 30 days on both of them.
Right. Yeah, the victim even said it was a long time ago. Okay. All right. Okay, I have no further questions.
Mr. Prater?
Yes, so you're a 6th felony offender, correct?
Yes, sir.
Okay. How many times have you been on parole?
So I do right.
Quite a
Every
few,
time
huh?
Yeah, yes, sir.
You ever been revoked before?
I don't think so. I always been done my time. Go to DOC and do my time.
When you saying, were you even at the bar?
No, sir.
You weren't there, but you pled guilty.
I plead guilty to
Disturbing the peace.
disturbing the peace.
And the incident occurred at the bar, right?
Sir,
Didn't the shots in the air occur at the bar?
that was the person who said that. That's what she said, but I ain't do it, sir.
Well, why'd you plead guilty?
I plead guilty because it was a misdemeanor, sir.
Okay. Mr. Poindexter, as I said, you're a 6th felony offender.
Yes, sir.
And you pleading for mercy before the board here. How much more mercy can you have than us to have allowed you on parole for 6 different times for 6 different crimes, and you still continue to violate the law and plead guilty to violating the law? I mean, that's all the questions I got, Madam Chairman.
Yes, sir. And Mr. Poindexter, the fact that did plead down to disturbing the peace, you would have had to have been present at the bar to disturb the peace there. So that placed you at the bar that
it did.
to disturbing the peace there. You understand?
No, I thought like disturbing the peace could be like on any street, not just at a bar.
But the issue was the shots in the air with the bar, the gun being shot.
Well, when the judge told me I'm admitting your charges to disturbing the peace.
Okay.
That was that's why.
Okay. All right. Is the board ready to vote?
I don't know.
Yes, ma'am.
Okay.
All
right.
Please.
Okay. What would you like to say, sir?
See, I feel like if they're about to like revoke me in any kind of way that I could get all my street credits. So y'all gonna revoke me, sir.
That's handled by someone else. Mr. Freeman, can you lead off with the vote, please? Do you mind?
No, ma'am. My vote today is going to be you're a 6th felony offender. You pled guilty to disturbing the peace. Lady said you had a gun outside the bar. I'm gonna find him guilty of condition number 4, and my vote today is gonna be to revoke.
All right, Mr. Prater.
He, in my estimation, he had a gun out there, but he pled guilty to a lesser crime. And he's been on parole or he's had 6 felonies. And so my vote is violation of condition number 4, revoke.
And sir, I agree with my colleagues, violation of condition number 4 to revoke. And so today, sir, your parole has been revoked and the time is 10:37.
Okie dokie, friends. A few minutes left. Let's go back to Judge West one more time.
Good morning. Are you Mark Anthony Newell? And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Newell, in clause number 23, DCCR 0916, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation July 2nd of 2024 for the state jail felony offense of evading arrest or detention with previous convictions. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct? Answer out loud, please. Thank you. It alleges you violated your probation. Count 1 alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
That's true.
Count 2 alleges that you failed to immediately report to the probation officer your address change. Is that true or not true? Count 3 alleges that you provided a urine sample October 29th of 2025 that tested positive for marijuana. Is that true or not true? True.
It's true.
Count 4 alleges that you provided a urine sample March 4th of 2026 that also tested positive for marijuana. Is that true or not true? Count 5 alleges that you admitted to your probation officer that you were using K2 or synthetic marijuana on March 4th of 2026. Is that true or not true? Count 6 alleges that you failed to provide verification of completing the community service hours as required. Is that true or not true? Count 7 alleges that you're behind in your court assessed fees as of March 4th of 2026 in the amount of $2,020. Is that true or not true? Count 8 alleges that you failed to report in person to the Harris County Probation Department February 12th and February 26th of 2026. Is that true or not true? And then count 9 alleges that you failed to report to Jefferson County either online or by mail for the months of May of 2025 and then January and February of 2026. Is that true or not true? Did you enter your pleas of true to counts 1 through 9 freely and voluntarily? Did anybody force you to plead true to those counts?
This, I want to get this over with.
Well, so did you plead true to those counts because they're actually true?
Yes.
Okay. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
This one.
You fully understand them?
This one.
And you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Newell is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. And at this time, I'm going to revoke your probation, reassess your punishment in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you did waive your right to appeal. You probably already received the other, but just in case, I handed you the admonishment regarding your ineligibility to possess a firearm or ammunition. So because you have a felony conviction, you're ineligible to possess a firearm or ammunition. If you have any questions about that, you can read that document or ask Mr. Rojas. All right. Good luck to you, sir. You can go back with the bailiff. Thank you for being here, man.
Alrighty, friends, that will bring it to a close for this morning, but we will be back tonight for Sidebar right here on this channel, 8 p.m. Eastern, 5 p.m. Pacific. Do be sure to join us. It's episode 68. I can't believe it's 68 already. but it will be the only sidebar this week. We're not going to do one Thursday evening because of the upcoming holiday weekend, so do join us tonight. And of course, I'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, half an hour earlier if you are a channel member. I hope you enjoyed today. I know I did, and look forward to seeing you all soon. In the meantime, go have yourselves a great day. Take care. God bless.